now continue.
My lord, under compelling circumstances, my lord,
I'm having to mention, my lord, once again, my lord, on Monday, my lord, I sought for leave from your lordship. Your lordship was pleased to fix the matter today. My lord, it's an appeal, my lord, where Narcotics Control Bureau is the appellant. My lord, it is appearing as item number 21. My lord, I'm only beseeching your lordship, my lord, if this matter could be taken up, my lord, at any time, such as, my lord, 11:30, subject to your lordship's convenience. Why, my lord? Otherwise, my lord, if, my lord, by chance, my lord, in the first half, the matter is not taken up, since your lordship has another bench in the second half, my lord, the entire appeal would become infructuous. My lord, why, my lord? I'm telling your lordship, this person, my lord, who was the petitioner in the writ petition, my lord, he's a high-risk individual. My lord, after talking with the central government, my lord, as well as two state governments of West Bengal and Rajasthan, my lord, his transfer, my lord, was recommended for preventive detention. My lord, that
Don't argue the case.
no, my lord, I'm not saying that.
Which is the item?
My lord, 21, my lord.
If we do not reach the matter, mention at 1 o'clock with notice to your other side.
Lordship,
Notice to your other side come at 1:15 so that we can make some arrangements.
deeply grateful. I'm much.
May I be permitted to mention one mandamus appeal, my lord, against the order of demolition?
Why you are mentioning today? We take up Monday and Thursday mentioning.
Your Lordship, may I be granted leave to file an appeal without the certified copy, Your Lordship? The order, impugned order was passed on 9th. We have applied for the certified copy. There is some urgency in the matter, Your Lordship. Your Lordship, the petitioner.
You are the state appellant.
No, Your Lordship. This is the private respondent appellant, Your Lordship.
What is the urgency?
Your Lordship, the appellant is in the merchant navy and sailing, Your Lordship. By dint of this impugned order, which has been challenged in the appeal, Your Lordship, a direction or an observation has been passed for him to attend his mother physically at Kollani, which is not possible for him. Your Lordship will kindly takes it up any day convenient to your Lordship.
Go and file a recalling application.
Your Lordship will kindly takes this up.
There is no
A leave to file without certified copy, Your Lordship. Kindly grants a leave to file without certified copy, Your Lordship. I shall file and come back.
Urgency, madam. If there is a court's order to go and meet with the mother,
Your Lordship,
and if you cannot do so, you have to move an application.
Your Lordship, that was submitted before the honorable
drop off
bench, Your Lordship. Your Lordship,
appeal, na?
kindly consider that.
Try our luck in
Your Lordship kindly considers that is urgency. Your Lordship, the facts are such, Your Lordship.
July was the order passed.
In July.
When did you apply for certificate?
Your Lordship, on 10th itself, Your Lordship.
10th. We are on 14th. Get the certified copy, file the regular appeal, give the returnable date. Matter will be there in the list. Madam, what you are serious?
May I have your lordship?
I beg your lordship's pardon, Milord. I am virtually here. Milord, item number. Milord, I am the Advocate General of Odisha. For Milord, I may beg your lordship's pardon. Item number 1 and 2. That's a habeas corpus matter. It appeared last Monday at 12 noon, but I was held up in a part-heart matter, so my associate there, she made a mention. But unfortunately, Milord, I am flying today at 12. I have to catch a flight to Delhi. So actually, the two petitioners, they have already been released. There was no detention in the eye of law, but as that can it be taken up Monday next 21st? These two Orissa matters. I think some Delhi matters have been tagged. But in our case, those two persons have already reached their village. This has become infructuous.
We understand, but Mr. Acharya, please join us. Oh, you will be flying.
Yeah, I'll be flying. I have a 12 o'clock flight, so I have to proceed to Bhubaneswar. I'm in Qatar.
You will find us when it is called. So let us see how we can accommodate.
Much obliged.
May I have your lordship leaves?
I'm praying for Monday, 21st. Your lordship, please.
Your junior will be here. He will remind us when the matter is called.
But I'm so deeply obliged. I'm deeply obliged.
Lordship, leave to mention an original side matter. I need leave to file an appeal without certified copy. The impugned order was passed yesterday. I am on a writ appeal. My contract was performed. I have a threat when I received final payments. Now, when I was asking for release of my bank guarantees, the respondent authority gave me a show cause to blacklist and encash my bank guarantees. No provision for blacklisting. I intend to move it tomorrow, Your Lordship. There's some urgency. Impugned was passed yesterday. My bank guarantees will be encashed. I will be put on a notice of a blacklisting. I have performed the contract year back.
I don't understand. You have been returned the money.
I have performed the contract. I have received the final payments. After receiving the final payments, I write to the authority to release my securities.
Why didn't the trial judge give you?
Your Lordship, the trial judge did not give because the Lordship, the trial judge concerned that there is a disputed question of fact. I am saying there is no disputed question of fact. So I just want to intend to move it tomorrow, Your Lordship. There is some urgency. It's an admitted from the records, from the order of the trial date. Yes, the contract was performed. I received full payments.
File it, give the notice, it will be there on
Your
Monday.
Lordship, I require leave to file without certified copy and I'll kindly takes it up tomorrow, Your
No,
Lordship.
no, tomorrow we cannot. It will be, you file it, we are granting the leave, then you come and mention tomorrow, we shall fix at a particular date. Yes.
Your Lordship, my difficulty is that I'll be put to that blacklisting. I have, that's the difficulty. Kindly takes it up anytime this week, Your Lordship.
We cannot assure you because the benches have already been arranged.
Well, I'll again try after filing with the leave, mention it. I'll just try and.
We have asked you something.
Yes.
You file, we are granting the leave.
Great.
Give a notice to your other side and remind us tomorrow.
Oh, gratefully. May I have Lordship leave another?
Yes. Call.
There is another.
Sorry, today is not dimensioning day. Yes, call the list.
Well, it is that bank matter, my lord, where the
Yes, where's the
my lord, none of my learned friends are present here. Looks like I informed one of the learned advocate who was present representing my lord the auction purchaser.
yes, where is
Mr.
Mr.
Trivedi
Trivedi?
perhaps is coming, representing the
So
auction
where is
purchaser.
the appellant's advocate?
Appellant advocate are also missing, my lord. That matter, my lord, where they are supposed to inform this honorable
What
court.
happened? There had been any meeting?
We have not taken any, my lord, coercive action, as my lord assured by from my side, my lord.
So we dismiss the appeal. Nobody is appearing. Irresponsible.
Because they were only supposed to inform this honorable court the time limit within which they are supposed to vacate. Perhaps beyond that, they are not.
Where is Mr. Bodal?
Boral is also my lord. I can't see Mr. Boral as well.
Clark
13.
ধর না এটা ধর
এটা সেই মামলাটা সরিয়ে ছিল 13 বছর আগে এই রিপোর্ট তো নিচে নিয়ে আজকালকে গাড়ি
অরিজিনাল সাইড আছে আমাদের কালকে কি অরিজিনাল সাইড আছে আমাদের
My lord, apologies, my lord, when the matter was called.
Unqualified apology, my lord. I tender unqualified apology for not being able to be present, my lord, at the time of call.
Tell us, have you been able to find some solution?
My lord, practical solution, my lord, that they are requesting your lordship, my lord, that apart from anything else, they want to continue with the enjoyment of the property, my lord, for a period, my lord, till the about April, May 2026. Another 8-9 months. Now, today we are in the month of July, August to the end of this year, and again, you know, another 4-5 months. Because, you know, the daughter apparently is studying something, you know, she's going to complete the course, and the son is in class 10. He is going to appear in the class 10 board examinations. That is on the practical side. Since whatever has fallen from you, your lordship.
Are you willing to file an undertaking to that effect?
Undertaking, yes. And
By
you know, an
April
amount of,
2026.
I'm sorry,
By April 2026.
yes, April 2026. And you know, another thing is there, some amount of money is lying, about 5 lakhs and odd is lying with the bank. You know, that amount of money is, if it can be released or something, because the bank has,
It will be beyond our scope.
Unless
Unless the bank agrees, Mr. Bhattacharya.
I do agree. Now, that aspect is also, you know, to be addressed. You know, that is also on instructions. You know, that is on the, you know, whatever has fallen from your lordship to honor, you know, whatever fell from my lords. You know, I am saying this. But, you know, on a legal aspect, you know, there are certain submissions which your lordship may propose to go into, you know, that I leave it to the court. Because one judgment apparently is staring at my face.
Choice is yours.
Yes.
If you argue on merits, we'll take it up on merits. But even if you do succeed, let us assume you succeed, it will be a matter of time. If we do decide to set aside the order, the bank should just go back and initiate Section 14 proceedings once again. It will just be a matter of
But
time.
I am not on the Section 14. I am more fundamentally, you know, apart from anything else, you know, this is legal, you know, thing, you know, which I am not saying, you know, that I am covered, you know, because ITC stands in my way to a very limited extent, but it does. You know, I cannot, you know, make this submission before the highest court of the state that the law is in my favor squarely. Argument advanced in ITC is in my favor. But ultimate conclusion reached in ITC, Milord, is subject to correction, Milord. A grey area is there.
Absolutely.
A grey area is there,
Absolutely
which
agree.
I will, Milord, appearing for a litigant, definitely, Milord, seek to urge before your lordship that here, your lordship is looking into the facts of a particular case where everything transpired pre-14 stage. Everything, including the issuance of sales certificate and Appendix 5, including 9.6 and 9.8. Everything happened, you know, and the language in Appendix 5 is free from all encumbrances and no further dues. Those things can be gone into. But ITC, Milord, one observation in ITC stares at my face. That is also, Milord, very correct. Milord, I cannot, Milord, appearing as an officer of court, Milord, say something which is beyond the records. But factually,
Yes, Mr. Trivedi, what do you have to say?
Well, I have nothing to say, Millard. Let my learned friend complete, Millard. And then since he's proposing, Millard, because he initially he proposed, Millard, that he wants to vacate if a time frame is given. It was his submission on behalf of his clients. He wanted August. It fell from your lordships that April. Now, let him conclude where, as far as merits are concerned. If he wants to argue on merits, then I will have to come on.
Merits are concerned, you will be in difficulty.
Well, I am in difficulty all through.
You'll be in greater difficulty.
Well,
now.
maybe I'll be in greater difficulty, my lord, but I am in difficulty all through at 75 years of age.
No, that's not relevant.
Now, if something has been done by
Mr.
the bank,
Trivedi,
my lord, if something, the
hear
fault,
me out.
lordship, I apologize, my lord.
From the order of the DRT, you also preferred an appeal.
Lordship, I have.
Your appeal succeeded.
Lordship.
So you want to take your money back with interest, which the bank has been
That
directed
will
to
be
pay.
in crore.
Let the bank pay.
No, my lord, that
the
bank
will have to pay.
That the bank will have
It's
to
in
pay.
crores or
Lord, I have no issues. I have put my lord will kindly appreciate.
So, Mr. Trivedi,
Lordship.
with that, you've not challenged the order of the DRA.
No, my lord, I know that.
So you've won the appeal.
Lordship.
You take the money, interest, and go. Let
Lord,
the
in
bank
my
deal with
respectful submission, my lord, I, as an officer, once again reiterating what my learned friend has said, my lord, I have already told my client that, my lord, since we have not challenged that order, we are standing in no man's land. If your lordship so deem fit and proper, my lord sets us aside. Then, my lord, they have the liability to pay me because I have put yes, my lord. But then, in that case, my lord, my precarious situation is this, my lord. I am at present 75 years of age. It is neither here nor there. Now, my lord, even if I get that money back with interest, at least I can pay for my medical bills. But, my lord, if I get that house, my lord, because I am not trying to, my lord, anyway, my lord, let me be somewhere, my lord.
No, Mr. Trivedi, have you not given up your right to get the property? Once you file an appeal and the appellate forum says you take the
Yes, my
money
lord,
along
I
with
bow down. I bow down.
So there's a slight difficulty in so far as getting back the possession is concerned.
My lord, I bow down, my lord. But then if today, when the order has been set aside by this honorable court, things have shifted back to its original position because my order the order was a composite order.
No, but your part of the order has not been set aside.
No, my lord, the entire thing, my lord, has been set aside because the order in all other
was from the writ petition that your part was under challenge as well. Can't be.
My lord, the entire order was under challenge.
No, Mr. Trivedi. Bank was only concerned with the sale.
No, my lord, I stand corrected, my lord.
Section 14.
No, my lord. My lord, they had actually, it was my execution which triggered off the urgency in the matter. And at the time of argument, they argued on both the points, saying that we are ready and willing. And, my lord, as far as the order impugned is concerned, lordship, as far as order impugned is concerned, my lord, since I have anyway, my lord, I am the worst sufferer. My lord will kindly understand my precarious situation. I am not trying to say something, my lord, I hear, my lord, as I stand today. I have been put into a litigation.
What do you say, Mr. Trivedi, as regards this April 2026?
My lord, let me take instructions, my lord. My lord, from the very outset, my lord, from the first day, my lord, I just pointed out the facts, my lord. And I am on a mercy petition before your lordships.
Tell us what are you looking at, the possession or getting the money back?
My lord, if my lord will kindly, possession was always my first choice, my lord. Therefore, I lingered till 2019. It was only in 2023 that I asked for my money back because 9 years I could not see a ray of hope. That it was a compelling circumstance. So lordship will kindly see that. And my lord, now what has happened is, my lord, since because my lord, I am also a poor lady, I don't want to go into litigations. Now, my lord, what had happened is I was also left with no other choice. Lastly, my lord, when I thought that there is no ray of hope, then I made an application. Now, again, they challenged that order which was passed in 2023. The bank did not even take care or were not diligent to fight it out here. Now, my lord, my situation is such, my lord, that whatever falls from my lords, safeguarding my interest in any manner whatsoever, will be beneficial for him. Because, my lord, again, going into a litigation, अरे भाई पूरा बोल अप्रैल में अगर खाली करें आप आदमी हैं 1 साल नहीं अभी जुलाई है अगस्त सितंबर अक्टूबर 9 महीना
You waited 9 years, another 9 months.
As my lord's officer, my lord, I am competent to mediate. My lord will kindly not lose hope on me. अगर आप देखिए, अगर आप लोगों को ऐसा चाहिए,
Mr. Trivedi, you have a talk with your client and come back.
lordship. But my lord, I am hopeful,
On
my
the
lord.
basis that your clients are willing to furnish that undertaking by April next year, they will vacate the premise.
मेरे भाई अंडरटेकिंग देंगे वो सारी राइटिंग होगा और अंडरटेकिंग हो ऐसे थोड़ी ना होता है बेंच का ऑर्डर ऐसे थोड़ी
Mr. Bhattacharjee, you draft an undertaking. Ask them not to sign it. Keep it ready with you. We are fixing it next Thursday. Done. Otherwise, we pass order on merits of the matter.
I'm
If
grateful.
Mr. Trivedi somewhat bargains with that, say, if it is January, I will be agreeable, whatever it is.
No, my lord,
Whatever is
I-
resistance.
But one thing, Milord, apart from this particular matter, undertaking, I'll come with a prepared undertaking. Actually,
That is for your benefit.
I understand. But one thing, Milord, I request both my lords, Milord, since my lords are hearing this sort of a matter, kindly lay down the law. Kindly lay down the law. That is also something, Milord, it's troubling me, Milord. Kindly pardons me. Kindly seize the language of section 14. Kindly secured creditor. Milord, on provision of loan, ছেড়ে দেবো কি টাকা পয়সা আন্ডারটেকিং ড্রাফট করে নিয়ে আসতে বলছে সই করতে মনে করছে নেক্সট থার্সডে রাখছে
Yes, Ashok. Mr. Bormon, don't take any coercive
My
steps
lord,
in the
my lord. We are not, because my lord, we have applied, but unless and until police asks for the depositing the my lord
No,
requisite stamp,
we are asking you not to take any coercive steps.
but we have not taken any coercive action,
Please don't.
because only the police will first inform us the money to be deposited, then only we can take. We have not initiated any action, my lord. I had assured from my side.
কিছু কে বলছে তুই আমাকে বলিসনি
Do we record that, Mr. Bormon?
কেন বলছে আমাকে ফাঁসি দিয়ে
It will be safer for you, no?
My lord, my client is aware of the situation, my lord. What is going on in the room,
Then
my lord.
don't do anything.
My lord, I assure my lord. From my side, my lord, I can assure my lord.
তাহলে ছেড়ে দাও next Thursday.
Deeply.
You prepared the undertaking. Ask him not to sign it. You bring the original. We will hear Mr. Trivedi and then decide.
My lord, I apologize. My lord, Justice Mitra, I apologize. My lord, I was in
For what?
my exuberance.
Yes, next.
I'm grateful.
We mentioned to take a letter. হ্যাঁ, we mentioned it. Item 6, yes.
Uncle the state.
Yes.
The report are there. But the report are there.
Where is the petitioner? Petitioner not here.
This is the matter where a person has been missing and this application has been filed after 13 years. She was an employee, contractual employee of the KMC. The wife was eager to have his job. But job was not provided. She wants to get the benefit from the court that she is untraceable. If that observation she can get from this court, she is of the opinion that she can get the job on contractual basis at KMC. That is the summons. After 13 years, this has been lodged, filed.
He's missing for 13 years.
Yes, 13 years back. After 13 years, this habeas corpus has been filed. Firstly, she has lodged a complaint as Jharkhand. my lord, comes to the page the page after page 9, page 11.
Page 11.
Yes, my lord. Initial complaint was lodged at Jharkhand. My lord will see the round rubber stamp of Jharkhand.
No.
Then,
He went missing from 2011.
yes.
Oh, Jharkhand was reported. Then
Okay, then reporting of Jharkhand has been diarized with our police station, with Bortala, that I have made a complaint with Jharkhand. This is for your reference.
I see.
This is for your reference, future reference.
Where are you?
My lord, I'm for the petitioner, my lord.
Yes, what do you say?
My lord, I don't have the brief, my lord. The senior matter, my lord. I don't have the brief, my lord. The senior is on the way, my lord. He is from Sialda Court, my lord. Sharik Siddiqui, my lord.
Ask him to be here. Where is he?
He is on his way, my lord.
This is the letter given by them that they could not fund, they are unable to furnish the document. It's in
But
Hindi.
not being able to give the PAN card details, Aadhaar card details.
My lord, on the next date, my lord, I will provide all the documents which required.
She has written unable.
You have made a representation, is nothing with me.
Photograph, Aadhaar, PAN, কিছু দিতে পারছি না।
What do we do, madam?
My lord, kindly adjourn the matter for today, my lord. My lord, I don't have the brief, my lord, also.
Mr. Mukherjee, learned APP, appearing.
I'm for the state.
My lord, I'm for the private respondent.
7.
My lord, the affidavits have been exchanged.
No, the affidavit in reply be taken on.
Yes.
Bacha custody. I am the mother of 2 children. One is 4 years and one is 12 years of age.
On the last occasion, my lord, we have produced the father who is a civic volunteer along with the 2 children before this court.
No,
On the,
it was not true. Piracy.
My lord, they were
Inside
there
the
before.
court.
But they were
They were there
with the
before
two children.
with two children, my lord. One
Maybe I have to.
4-year son, my lord. The mother even interacted
The
with
mother,
children.
No, my
the
lord,
mother,
outside
the
the
mother-in-law,
code, what I
the
have.
mother-in-law, the father-in-law, the husband, the civic volunteer, along with a girl child and a boy child on the lap of the grandmother.
Probably.
Everyone was present before this court.
My lord, your lordship asked me, why did you bring the children before the court? Did we ask you to bring the children? My lord, I said that I asked them. My lord, they were there.
Yes, yes, yes.
Yes.
Oh. So,
They-
Banerjee, you have seen your children. What
My
is
lord,
your
the
problem?
difficulty is, my lord, I pray for custody. My lord, they have been forcefully taken away. That is my prayer.
Argue then on merits. But
But,
we tell you, if we hold against you, you would be having problem in your guardianship act. Because you have said on instruction that don't do anything, allow me to meet with my children once. That has been done. Now, if you change your stand and you argue,
I cannot.
we
My
will,
lord, then, my lord, kindly visualize as a mother. Last,
we will consider your
well,
claim.
just one, before going into the merits, as a mother, last 8 months, I have only visited my child, if yes, only once in court. Well, once in this court, in the last from last October till to July. Now, my lord, what I pray, my lord, at least a visitation right per week. At least this much be directed as a mother, 4-year-old son, my lord, forcefully taken away by the father. He is a police officer, civic police maybe.
So, Mr.
But
Banerjee,
still-
you must be static with your point. You take instruction and make one submission. Next day you change.
No, my lord,
This is not
because
done.
my lord, I have not seen my child for the last 8 months. October, November, December, January, February, March, April, May, June, July. This has been the time.
Yes, Mr.
My
Chakraborty.
lord, if your lordship kindly comes to my affidavit in opposition once. My lord,
No, before that we hear
My lord,
you.
I have even approached the police, my lord, several letters allow me to visit my child. Only, my lord, when it was brought before this court, I have seen my child. That too, my lord, in this long period of time, the child have been brainwashed. Both the child are now not coming to me. My lord, is it fact, my lord, someone forcefully take away? My lord, he may be a natural guardian. But, my lord, there are time and again, my lord, the honorable court has intervened even. My lord, I can show
Your
from.
misdeeds the children.
My lord, how can, my lord, mothers misdeeds, my lord, whatever the husband is saying, my lord,
Because we have not heard him, we will hear him.
my lord, he is having only one allegation that I am having some affair with some other person. My lord, there is no, I categorically deny about it and I stay in my parental home.
You place it, Mr. Banerjee. What is your case here?
But I just.
But are you agreeable to give him visitation?
my lord, the petitioner, my lord, has left the matrimonial home with her paramour. She has now married some other boy. My lord, that is at page 20 and
Very
21.
good. We shall go to that. Are you, if we specify any time for visitation, are you standing in the way to that?
My lord, may I take instance?
Yes, yes, take instance. ও তো এসব বাপ মার ঝামেলা সামলা হলো।
তাতে অসুবিধা নেই তো, কিন্তু কমন প্লেসে আর এল্ডারদের সামনে। My lord, I do not have any objection to that. My lord, if the children are my lord, if the mother meets the children in presence of the elders of both the family, and my lord, in presence, my lord,
That
of
will
the
be
police.
That will be problematic, my
Because
lord.
my lord, sir, আমি একটু বলে নিই। My lord, the petitioner has, my lord, even after filing of this habeas corpus application, after 2 months therefrom, she has filed a 156(3) application, my lord, alleging torture and 498A against me and my lord, her in-laws. In that 156(3) application also, she has nowhere stated that I have snatched away her children from her, I have kept them, I have detained them to some other unknown place. My lord, I have made them admit to my lord, good school
All
in
right,
our locality.
let us go into, yes. make
And
your
honoring your lordship's view, my lord. My lord, the other day, the father was asking the little boy to go to the lap of the mother. The boy and the girl all denied to go to the mother.
And my lord, the
That is
police has
because-
Yes. So some arrangement has to be made so that
My lord, we
persuasion,
have no objection to that.
persuasion has to be made through some elderly person who can pursue them to be familiar with the mother.
My lord, that is what I am saying, my lord.
So let us know the facts.
My
You
lord.
place the facts.
My lord, I have made a specific allegation, my lord, that is at page 23. My lord, I went to the police station to give the...
Are you a working lady? Are you
No,
a
I am not a working lady, my lord. I stay in my parental house. I have been thrown away from my husband's house and I have come with the two children to my parental house on 11/10/2024.
page?
My lord, page 23. It is, my lord, first, second, third,
Of the
fourth,
habeas
fifth,
corpus
sixth, seventh, eighth, ninth line from the bottom, 10th line from the bottom. My lord, on 11th of October 2024, my lord, I left, I was compelled to leave my matrimonial home and come to my parental house. That is on 12th. 11th I was compelled. My lord, may I just read it out? আমি শ্বশুর বাড়ি হইতে বাপের বাড়ি আমি ইংরাজি 11/10/2024 তারিখে এবং ছেলে বাপের বাড়ি ইংরাজি
Yes,
11/10
we have read it. Then what happened?
My lord, thereafter, my lord, my lord, went to the police authorities. I went even before the learned court below, my lord, the two children was taken away. We are having matrimonial disputes. It is admitted fact, but my lord, it is absolutely denied and disputed, my lord, that I am having a...
You are living with your parents.
I am living with my parents. I have specifically stated in my affidavit in reply, even my address.
So how will you maintain the children? You are,
Well,
you are
both
not a
are, my lord,
working lady. You are
my lord,
not a working lady. What
I'm
is
not
your
a-
source of income?
My lord,
How
my
do you-
source of income is I am living at the income of my parents. And first, second, my lord, so far as the maintenance of the children is concerned, my lord, husband cannot deny its responsibility. And so far as growing up of the children, my lord, mother is, my lord, kindly see the Hindu Guardianship and Wards Act. Natural guardians of Hindu minor, duto copy though. Page 77. My lord, this is not the fashion, my lord. If he wants, my lord, kindly see the law below 5 years, my lord. What is the law? The natural guardians of a Hindu minor in respect of a minor person as well as in respect of minor's property, excluding his or her undivided interest in the joint family property are, in case of a boy or an unmarried girl, the father, and after him the mother, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be mother. My lord, I have one son, my lord, who is having 4 years of age. From 3 years, my lord, 3.5 years, my lord, she has been taken away. I am on the point, my lord, they had been forcefully taken away from me. And last 8 months, my lord, I cannot even see. And by this time, by this long period, my lord, a natural guardian, mother, my lord, the children will be brainwashed against the mother. Today my son will grow up, my lord.
Mr. Banerjee, you have to go to this is a summary procedure. All your argument are substantial
My lord,
before the
kindly,
appropriate
yes,
court.
I bow down to your lordship, but the fact remains, my lord, if I go before the, why I have come up before the writ court, my lord, I'll show two judgments. My lord, today if I go before the district court for getting the custody of the child, the matter will take at least, my lord, some years to get some order. By that time, my lord, my child will not be knowing that I am his mother. My lord, kindly come
You
to
have
one.
not gone through the provisions of Guardianship Act. You can
My lord, just kindly see, my lord.
make appropriate application there.
My lord, at least some visitation right, your lordship may kindly confirm. My lord,
Yes,
kindly.
that we are considering.
My lord, 2020.
Visitation right we are considering.
Your lordship is considering the visitation right.
Visitation
But,
right I am
my lord,
considering.
one thing, my lord, I would pray, my lord, if any person remains there, particularly the husband's family, my lord, that will create some problem. If I go, my lord, I should go with my parents to visit. At that point of time, the husband's family should make some distance. This is
Yes,
my
what do you
respectful
say?
submission.
My lord, to the visitation right. My lord, so for the maintainability of this my lord, of this habeas corpus application, my lord, the children have not been detained to some unknown place. They have neither been snatched away from the custody of the mother.
Matrimonial suit has been filed by whom?
My lord, the divorce suit, my lord, by me.
This judgment.
Because when she left the house, left me and her children with her paramour, she married her, my lord, another boy, my lord, social marriage. My lord, when she married, my lord, if your lordship kindly comes to page 20 and 21, the daughter who was then aged about 11 years, 10 years to 11 years, grew up seeing her mother to be in an illicit relationship with another boy. My lord, the local people of that locality also found this lady with this boy in objectionable conditions on many a times. My lord, the
My lord, so far as
স্যার আপনি একটু বলে নি, আপনি আপনার সময় আমি একটা কথাও বলিনি। এখন জজ সাহেব আমায় জিজ্ঞেস করেছেন, একটু বলো।
not been suppressed. It has not been suppressed. My lord, it has not been suppressed.
My lord, times and over again it has been held.
My lord, I can.
My lord, times and over
My
again.
lord, it has not been suppressed.
Try to settle the amount. 4 years son and 6 years daughter.
My lord, my lord, 12 years daughter.
12 years daughter.
My lord, I have never deserted her.
This
that
washing
wife.
dirty linens in public. You are against your wife and the children.
My lord, I have never let my wife go.
There is an acrimonious relationship between you. In this sort of an acrimonious relationship, neither the children will be in their naturals, there is safety neither in your hand nor in her hand.
My lord, we,
Now the additional problem is that you allege that she is having another relationship. So when it is a matter of 4 years boy, you can't apply your mind. You wed husband and wife at a one juncture.
my lord, I bow
Now we
down.
will give visitation right. You people will again fight there. Again police complaint will be lodged.
My lord, visitation right, my lord. I
How
do
can
not.
we repose faith upon you? Tell us.
My lord, the wife, subject to lordship's correction. My lord, the wife has deserted her children.
Mr. Chakraborty, you are our officer.
My,
Why don't you sit together and tell us that whether some sort of settlement can be arrived at? 4 years child, 12 years daughter. What will the daughter grow up seeing? What matrimonious relationship between you?
my lord, subject to lordship's correction.
And
My
the
lord, the
person with whom he's saying, she would be saying your mother is another relationship. She's dirty linen or what?
my lord, I bow down to your lordship. My lord,
You have a responsibility towards the society also. They will not understand. They do not, maybe having not that intellect. He is a civic volunteer. He thinks that police is in his hand. But
my lord, the,
we wouldn't have gone to that extent had the children been of 15, 16 years. Today, a 4-year-old child, she is the mother. Whatever allegation you might have against her, is it not proper that she should be she at least he must be seeing her mother?
my lord, I am not on the, my lord, I have no objection to that.
You
Subject
may
to
not
lordship.
have any objection,
my-
but we are having hesitation.
My lord,
Because if today we pass an order that every Saturday and Sunday he would be visiting, again there will be problem amongst you.
my lord, may I submit something?
You
My lord, may kindly keep
you
this.
you sit with Mr. Banerjee.
My lord,
You sit with him. See if anything you can bring out any sort of solution. Any sort of solution. At least for the sake of your
my lord,
children.
my lord, may I submit something? My lord, the matter may be referred to the mediation as well. My lord, if
Mediation won't do, we will mediate.
or my lord, may keep this
We
matter,
will mediate.
my lord, may keep this matter pending, and my lord, with a visitation right on the mother, my lord, we do not have any objection.
No, we won't keep it pending. Either we decide this way or that.
My lord,
We want to give you an opportunity, since you brought the children,
yes.
to give you an opportunity to sort out the problem. If it cannot be done, very good, we will pass our own order.
My lord, the mother wants the child, my lord, children back. My lord, her claim is that only, my lord, she has pleaded that in this habeas corpus application.
We are keeping it after 2 weeks. You apply your good office. You both
I am
the
always
person you
My lord, I am always, my lord.
If anything comes out, very well. Otherwise, we decide the matter.
My lord, at the end of the day, my lord, the welfare of the children is of paramount importance. My lord, if the child sees that their mother is in, my lord,
Then, my lord, I also have allegation against him.
my
He is also keep.
Mr. Chakraborty,
I have not uttered this
allegations
for
today.
once.
Leave aside the allegation. We have not passed any order in
Right.
his favor.
Right.
We could have disposed it of giving visitation right.
my
But we feel in this sort of an incongenial atmosphere, problems will elevate. You apply your good
My
office.
lord,
If anything can be said, if you can agree upon that, very
my
good.
lord,
You also lead a peaceful life. Let the children also lead a peaceful life.
my lord, I
Let the affidavits exchanged by the parties.
my lord, affidavit in opposition was
কি হলো? কেউ নেই? Records reveal that no one appeared on behalf of the petitioner when the matter was last taken up for hearing on 18 June 2020.
Your Lordship, I'm on the behalf of the petitioner.
That is, sir, why you are not physically before us?
Your Lordship, I'm suffering from the heavy fever, Your Lordship. That's why I'm not been able to do this, Your Lordship. Sorry.
Then you get well and come back next week. Yes,
Very much obliged, Your Lordship.
Next item.
My Lord, for the petitioner, my Lord. My Lord, last occasion, your Lordship give a direction to present investigator officer of this case, my Lord.
এটা কবে হবে পরেরটা? 23rd. Investigating
Until
officer.
now, my Lord, the victim has not been recovered, my Lord. Already 6 months has been passed, my Lord.
এই তো Forensic.
Yes, Mr. Mukherjee.
Milord, we have formed a SIT under the supervision of a deputy superintendent of police. Milord, earlier we have arrested the mother, but nothing came out. Now, Milord, under suspicion, mother of the accused, whom the girl has fled away.
What are the ages?
16 years, my Lord.
16 years.
And the boy?
Boy, my instruction was 22, my Lord. 22, not
22. 17 and 22.
Then you arrested the mother.
But nothing came out from the mother. Then, Milord, we went to Bangalore. From there, we have arrested the elder brother.
That is Boga. Then
he is in police custody. Boga is in police custody. Milord, the mobile phone which he was using, Milord, it is no more operating, and even he is not using the same handset, inserting a separate SIM, because the IMEI number is not available on our portal. Milord, thereafter what happened, Milord? Milord, we have obtained the bank statement so as to ascertain whether, Milord, the elder, this Boga, has given the accused has no bank account. So Boga has a bank account. We have taken the bank account of Boga, and we are trying to ascertain whether Boga has given his ATM card to his brother so that he is withdrawing money for a subsistence. Now we will see whether cash are being withdrawn from the particular Milord, ATM counter or not. That is on process, Milord.
And you have constituted a seat under the
supervision of a deputy superintendent of police. But we have obtained the bank details of Boga. We are of the opinion that Boga might have passed on the ATM card to his brother, by which he is withdrawing money. If now we have taken the bank statement, we are working on it. If by chance, Milord, it clicks that from a particular area cash are being withdrawn from the ATM, then we can ascertain, Milord.
So how did you get the this information from
Boga arrested? Boga gave his account number. Accused do not maintain any bank account number. Accused do not have any bank account number.
Mr. Hassan, learned advocate appearing for the petitioner, submits that the victim girl Next. You also cooperate. You also cooperate with the police. You people are not responsible about your children. প্রেম করে পালিয়েছে।
My lord, I am for the petition. My lord, till that the victim boy could not be traced out.
Petitioner's son.
Petitioner's son.
Yes, Mr. Mukherjee.
Boy is aged about 18 years. He was possibly kidnapped. And immediately after that incident, phone calls came for ransom from two unknown number. We have the petitioner has also mentioned that phone number. Fact remains
Any
that-
private respondent?
No, my lord.
So, what is the story?
The story was that on the date of fateful incident, the the victim boy was called upon by the two neighbors of the petitioners, and the boy went away with those persons in a scooty. Since then, the boy could not be traced out. On November, the incident happened on the November 26th.
During PC leading conditions.
But he is working in Goa. For 2 days, he has come in Bishnupur area to have the money provided by the state government for for purchasing of tab by the student. হ্যাঁ ট্যাবের টাকা নিয়ে চলে গেছে।
So far, my last information, the investigating officer informed the petitioner.
So, Mr. Mukherjee, if he is in Goa, you have already been there. You obtain a statement from the boy.
Yes. But we are sure it's well, it will not record it that he has come for 2 days to avail the facility of purchasing a tab which the state government was providing to the student. Now, after having the money for the tab, he went away again to Goa. Our team has went to Goa.
Gone to Goa?
Yes.
But on 14th, last week on 14th of this month.
You are the father?
Yes, my lord. Petitioner was informed that he had to go to Goa too, but subsequently the police informed, no, you need not to go to.
Pursuant to the earlier order passed on 18 June 2025,
Item number 11, my lord, I'm praying for short passover, my lord. Counsel leading me is in his legs.
Next Wednesday.
My lord, kindly.
There was the allegation. He is the son-in-law. There was the allegation that the mother-in-law.
My lord, my counsel is on his legs, my lord. Kindly.
Their allegation is that mother-in-law has been illegally detained by some promoter and tenant.
Oh,
yes. Because my lord, we have video photographed. We have video photographed the statement of the mother. The mother is also present in court. Their allegation is that the mother-in-law is untraceable. Mother-in-law's statement was that he has been asked to complain of against the tenant and the promoter. But the development agreement has duly been signed by the mother-in-law. Since the developer is not of their choice.
The petitioner is the son-in-law.
Son-in-law.
Of the
Lord, petitioner is not the son-in-law. Petitioner is the daughter.
Daughter.
Petitioner is the daughter. Your allegation is that your mother has been forcibly detained by
by the promoters and other antisocial elements of the local.
So now your mother is here. So finished. Problem solved. You talk with your mother as well. আবার ওনাকে পেছনে বসে মিস্টার মুখার্জি কি কথা বলবো কি কথা বলবো your client.
My lord, he is not present at this moment, my lord. He is coming. He's coming. My lord, kindly keep this.
She is here, man, sir. He's an aged lady. How long will she wait?
Short possible, my lord. Counsel.
কি অসুবিধা হয়েছে? আপনাকে ছেলেরা আটকে রেখেছিল?
হ্যাঁ আমাকে তো
In the report, my lord, the previous day report. My lord, she has lodged the GD, and on the officer in charge, Purnima আমার জামাই তপন পাল এবং আমার মেয়ে বাসন্তী রায় আমাকে হুমকি দিচ্ছে এবং আমার ছেলে বিশ্বজিৎ বিশ্বাসকে মারধর করছে এবং তার মেয়েকে মারধর করে আমায় হুমকি দিচ্ছে।
That is from the earlier police report.
Earlier police report. Can you see the annexure? Annexure B.
And mother also complained a letter to the Chief Justice regarding this, my lord. And I'm 5 respondents.
You are the son?
No, my lord, 5 respondents appearing in this case. 9, 11, 13, 21, and 22.
Who are they?
Either the developer or the tenants.
Both mixed, both of them.
Developer and the tenants.
They are the developer, all the my lord, the private respondents, my lord, private respondent number. This 11, 12, and 13 are the developer, and others are the my lord, tenants and co-sharer of the particular property.
এটাও স্যার অর্ডার ডিসমিস
My lord, from respondent number 7 to 10 is the tenants, and my lord, 11, 12, 13 are the developer, and other respondents starting from respondent number 14 to 25 are the co-sharers. Sorry, are the tenants.
Records reveal that the petition was preferred. Content Yes, Mr. Chatterjee, you will be surprised to note that in what matter you have been engaged.
My lord,
You don't know.
I am appearing.
Well, admittedly released, but our humble submission before this honorable court, their detention was illegal. In violation of my lord Ornesh Kumar, in violation of DK Bose, in violation of International Covenant for the Civil and Political Rights, and human.
One line that you have asked for compensation in your petition.
My lord, the compensation, my lord, I am before the.
Please don't talk, you show us that line.
একটা ডকুমেন্ট নিয়ে আসছিস দুজনকে দেখাচ্ছি দুটো তো কপি করতে পারিস
My lord, page 13, FG, my lord. It's a broader sense, my lord, cost and cost incidental there. But in this, my lord, no, my lord, kindly see, my lord. My lord, because but I intend to.
Mr. Chakraborty, we tell you. Your relative has been released.
True, my lord.
Now the matter was mentioned before us today morning by the
Advocate General, I have heard.
of Odisha. He's saying that I am coming here. Maybe he would be reaching.
He's going to Monday. Monday.
Let this matter be taken up, my lord, subject to lordship.
Not on 21st,
Because, my lord,
21st not.
we intend to.
21st July not, 22nd, 23rd. 22nd, 23rd.
We
Pardon,
intend
my lord?
to place our argument.
My lord, I take, can I just wait?
Just
Can I, your lordship, permit me to say?
No, we will allow you. The 21st you are there.
No, 21st, not 22nd.
Huh?
21st July, can I come to court?
You are questioning the court that whether I can come. You are a free man.
Your lordship.
Or not released, my lord. Possibly they are deported to Bangladesh. That report is
The two Odisha matter.
Odisha matter released.
So one is for one, sign note, the other one.
Third one is for Milord. This is or Delhi, na?
Yeah, Delhi. Yeah, খুশি আছে।
উড়িষ্যার গুলোই তো ছিল।
Not available. Milord, huh? আমি আছি my lord I am appearing 3 and 4
My lord, here they have detained my lord in the Karjunagar police station of Delhi, and thereafter, my lord, their whereabouts are not known to us. Possibly they have deported. And what happened meanwhile, my lord, since we have filed this case, the relative are taken into custody of the Karjunagar, subsequently released. That being the situation, my lord. One full night, my lord, they have detained the family members because as to why, how dare you are.
Presenting the other respondents.
my lord I am appearing for the state of West Bengal and police state of West Bengal police my information my lord we have inquired we went to this district Birbhum district they used to stay here now my lord they are the all that labor.
Did your chief secretary have any conversation?
Yes chief secretary has chief secretary এটা কই
chief secretary না এটা home secretary পাঠিয়েছে
From
Okay,
court lordship assigned Mr. Trivedi.
where is that
Where is Mr. Trivedi?
yes
To look into the whole issue.
এটা কি
পাঠিয়ে দাও কমিউনিকেট করেছিল অর্ডারটা
No, why
No.
why are you
My lord,
in
this-
such a long distance?
my lord
from
chief
Mr. Barry?
my lord chief secretary was not available the home secretary has sent this letter chief secretary was that on that day your lordship passed the order that time he was at Ranchi so then my lord home secretary has sent the letter with the copy of the petition and order
The direction for filing.
not much very impressive to me also
এতে লিখেছিল
ওটাতে এখন তো ওটা হচ্ছে না
Bring on affidavit before my lord takes up, because there was a writ petition with habeas corpus was filed before the Delhi High Court in connection with the same persons. The mother had championed for their cause and sister had championed for their cause respectively. That writ petition of habeas corpus was dismissed on this understanding by the Honorable Court, Delhi Court, that they have been deported. Then they withdrew that.
না 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 আমার একটা দিতে হবে না ভাই নিয়ে ধরে থাকলে কি করে হবে
That order was passed by the Honorable Delhi High Court on 30th of June. Now, suppressing that fact, they made a representation on the 7th. The person who's claiming to be the father, that is going to say the first, saying that I will move a writ before the Honorable Delhi High Court. Pursuant to that particular representation, they have filed a writ before the second writ on the 9th of this month before the Delhi High Court challenging the FFRO's order and deportation. Now, and they are again filing and they are maintaining this writ petition before this Honorable Court. Now, my lord, we want to put it on affidavit. My lord, this is the Delhi High Court order, my lord.
give it to us
I'm giving it. Now, my lord, I want, it has been, but my lord, this has to be taken serious notice. Therefore, I want to come on affidavit. My lord, as is also, my lord, adhering to him, my lord. Now, my lord, this is the fact, my lord, which should come, my lord, because suppression. One person.
Today, what is the status, Mr. Chief?
My lord, they have been deported, and that particular status was
Put it on
26 June
24th of June.
26 June
24th of June.
And my lord, that is reflected in the Honorable Delhi High Court's order. They withdrew it on that. Okay. But I yield.
Deportation হয়ে গেছে বলে ডিসমিস করে দিয়েছে এটা চ্যালেঞ্জ করে
So that challenging the deportation order, now a fresh petition has been
It is
filed.
pending before the Honorable Delhi High Court, and that will be taken up. Now we want to come out on, I have got entire instructions. The order which we have placed, the copies of the writ petition, the same name. And when they have knowledge, they suppress that before this Honorable Court in this writ petition. And whatever happened in Delhi. Now, I am not on that because this is the highest prerogative writ. But I am not on that. But then suppression, where the Honorable Delhi High Court is already in session of the second round of litigation.
what is the second round of litigation একটাই তো দেখতে পাচ্ছি one order
No, that second round is pending.
no I will come
Petition order.
let them bring entire things on facts Miller.
Yes,
May I just let him finish I will sit to him
Lord,
Now these, now Mr. Do you have the second writ petition number which has been filed?
সেখানে সময় ফাইল করবে বলে
My lord will kindly, my lord is marked, my lord, my copy, my lord, will readily, my lord.
You put in by an affidavit.
My lord, that is what.
In by an affidavit.
If the order of deportation on the basis of Harun's order is executed, how is the habeas corpus petition is maintainable here?
Then come on record.
We'll see to that.
Record before us.
We'll see to that.
To produce that, Mr. Chopra.
We'll see that.
The question of multiplicity of cause of action does not arise. So the cause of action arose that day. It was approved there.
All right, all right.
Can I?
Come before us.
Can I submit?
Like to ascertain what has been said, what you will be stating in your affidavit.
Can I submit?
So you have anything to say?
Yeah, I have something to submit. Question is, Milord, whether deportation or no deportation, he is a citizen or not citizen. Very nice. Milord, what I am submitting, just since the two matters have come, to your lords. These 3 and 4. Milord, will lordships kindly consider one thing. Let them, when they are filing the affidavit, until now, how many Bengalis have been detained and how many Bengalis have been pushed back? We are not aware. It is petitioner has filed his petition. Delhi, we are not aware about the fact. Habeas corpus petition even is maintainable by the relatives.
What do you say about this conduct? Writ petition was filed on 8th July. We took it very serious. And you were online on that.
Yes, yes.
You were also very anxious.
That the Odisha matter, huh?
You were also anxious.
Yes, yes.
You also want to submit many things before us.
Yes, yes.
But what is this conduct? Was it not his responsibility to write one single line that, my lord, we have preferred an application before the Delhi court? Nobody would have been any tension.
That is in respect of item 1 and 2.
No.
Odisha, not Odisha matter.
2, 3 I am talking.
3, 4. 3, 4. Yes.
And he is responsible.
No, what has happened? I tell you, what has happened. Let's come to the ground.
Had you been on the other side,
No,
Mr.
I'm sorry. But just kindly just. What has happened, Miller? If the arrested and deportation has been made, they are not aware. They are the relatives.
No,
no. The person concerned who have filed the writ petition, they are, and these persons are not same.
But championing for the same cause.
Oh yes, not the same.
Father has filed this, my lord.
I am saying they are not the same person.
Wait.
Had it been in our knowledge, I would not have dared.
It was very much within your knowledge.
No.
That is why you are not bringing Bodhu Sheikh.
No, my lord. No, my lord.
Filing it through another gentleman. Who
No,
is a relative
because
of
they are.
Don't say no, Mr. Chakraborty. It is your averment in para 1.
My lord.
Don't try tricks on the court.
I am not justifying, my lord. At the same time,
then what are you doing? You are justifying.
Had it been, my lord, in our knowledge, I would have, my lord, that being the situation.
How can we believe you, Mr. Chakraborty?
So
Bodhu Sheikh was the person who approached whoever has approached the Delhi court, their relative has come to you as a client. Was it not your duty to ascertain that have you filed any application? And are we to believe that you had no information whatever? You think our orders are scraps of paper? Believe me, you we passed this order.
My lord, it was not within our knowledge.
You are creating tension in the entire atmosphere. We will hear Mr. Bandyopadhyay if this allegation we will be hearing. But was it not your duty? You are creating an uproar without saying the facts before the court. This is not expected from a Calcutta High Court advocate.
Once again, my lord, in a very
কেন তুমি তর্ক করছো? জজ সাহেব কাছে বলো,
deeply obliged.
পরের দিনকে ঠিক করে আর্গুমেন্ট করো। কেন তর্ক করছো? জজ সাহেব বলছেন সেটা মেনে নাও। There are 2 superintendents, no doubt. My lord, there is some mistakes have been committed. There's there's no. No, no, I understand. Kindly just.
He's not.
Kindly-
He's not a junior.
Lord, I am not supporting you. I am not supporting what I am submitting. Lord, kindly aware. Lord, when they are filing this affidavit, let them also disclose
Will allow them to file, but
how many persons.
what impression people will carry about the High Court. Today, believing you, Mr. Bandyopadhyay, apart from you are an arguing counsel, but you are a member of our bar. Mr. Chakraborty, you are representing all Union of India and others.
Yes, my lord, and I am representing my lord, Delhi police also. My lord, may I just before your
So you one query. Will both of you file a single affidavit or you?
single. My lord, what we wanted subject to only relating to the question of further continuation of this habeas corpus petition in view of subsequent fact at Delhi High Court. Your Lordship can dismiss the writ petition on the basis of the suppression of fact, continuation of multiplicity of proceedings.
Let this come to us, Mr. Chakraborty. Let us go through it.
Relating to that issue, we shall file the affidavit.
Ashok, pursuant to our
But she has been picked up and said, "You are Bangladeshi." Now the point is, who will decide first? Appropriate authority, not the police, not the constable. There are number of procedures are there. You can't take someone, you are speaking Bengali, and this is also it is coming up from
No,
media.
that is why we are
That's
requesting
right.
Mr. Chok.
And all these cases, which are that so far the 3 and 4 are concerned, I have gone through the report of our state reports. Very alarming. Very alarming. Now the point is whether what they will place, then we will also place it. The question, Milord, the question is, Milord, we have come across these cases. This I am telling you, the National Green Tribunal, appellate authority is, the point is, even the Supreme Court has said High Court is having the jurisdiction. From the National Green Tribunal, even the High Court can. Similarly, if required, I will also argue, is a case where it is to be argued, because law, in a habeas corpus is a constitutional court of the state of West Bengal. But hands are, in a cases, the court's hands are also wide. It's not that. But
Let the affidavit come.
let the
Mr.
affidavit come. We'll sit. And give me a copy of the affidavit. Dies কিন্তু ভালোবেসে দিস deeply obliged to lordship.
I will waste lordship's 30 seconds.
আরো বলবি?
Lord, what from documents I have gone after the Pahalgam attack, what I understand.
Pahalgam তো কিছুই করেনি।
This happened in Kashmir with regard to the Pakistanis who were there. Now, Milord, there were, what we could understand, people were rounded up who were 160, 170. Everybody was released. It is not the case that any person who is speaking in Bengali was rounded up and deported. Here only what habeas corpus has come before my lord, only 5 people. 165 people were interrogated on the basis of understand and everybody released.
What?
Well, we will bring it, but then
Please bring those figures in.
No, but Milord, I don't want to make submissions of the cuff. I want to be, Milord, when it has fallen from.
What you are making a submission? Pahalgam is a completely different matter.
ASC is there, Milord. He will address. But
No. Pahalgam is a different matter.
We have only.
Our point is very clear. No, Mr. Devadi, don't say this. Yes, don't say. Only the
which you have challenged.
Yes, my lord, the order which was
You ordered, you have
Item number
said,
21.
yes.
where is, yes.
Also, I'm led by Mr. London Senior Counsel, Mr. Owen Bhattacharya. And
Where is he?
Lordship, he's on his legs, Lordship.
We told him to be here at 1 o'clock.
You've given notice also. Lordship, we have been just served with the notice, Lordship, some time back, Lordship.
Then where is your counsel? Tell us.
21. 12 or 21 দুটোই। টেনশন করার কথা না। ও ওটা তো জানাতে হবে।
Because my lord, time was sought for. That is the reason. My lord, it was served just, my lord, just 1 day before the matter was taken up for hearing.
No,
And even the Ministry of Finance, who issued the circular,
So
they
the
were
person
served.
will not say that, my lord, keep it tomorrow, I am coming.
It was said.
No, no, it is recorded.
It was recorded,
What
a
is
report
the
will
wrong
be
in
filed.
the order?
But the consideration on which the order was passed, your lordship kindly see the order.
That we will consider.
Yes.
We'll consider. Your advocate said, I am coming with a report. Court said, don't take coercive steps in the meantime.
No,
What
my
is
lord,
the
the
wrong?
way that past, my lord,
The
way that
security arrangement made you delay that. Security arrangement will be made on the date the order is vacated. Why should we interfere?
No, my lord, I'm telling your lordship.
By change of counsel, the stand cannot change.
No, I'm not saying so, my lord. The order
No,
on
the
the
way it is being mentioned before us. Yesterday it was mentioned, upgrade it. Today it was mentioned, upgrade it. So much of urgency in the matter, and the advocate engaged said that I'm coming with a report. And now we have to believe your version.
Now,
Mr.
my lord,
Poddar.
on the only one point is involved here, my lord, whether the pre-execution stage of a, my lord, the preventive detention order, whether the court can interfere or not.
Why didn't you go for cancellation of the bail? Finished matter.
No, it is not a question of bail. My lord, the Supreme Court is saying I shall rely on that. My lord, the bail is not at all a consideration.
He has obtained bail, na?
Which one, my lord?
This person.
My lord, there are no, my lord, that is not a consideration. There are 6 cases pending. One of the, my lord, case in Delhi, my lord, he's a, my lord,
All right, come at, you are there, na?
My lord, I am there. I'm led by Mr. Owen Bhattacharya.
Can you please come at, we have a different bench at 2 p.m.
My lord.
So please come at 3:45. Once we rise from that bench, we will sit again, reassemble and take your matter.
Absolutely, my lordship. Will come.
It can be 4 o'clock or it may be earlier.
It may be earlier also. Why I'm saying so?
Keep a touch.
Because the state, my lord, the state SLP in that matter also I'm appearing. The state SLP was supposed to be taken up on Friday. So there might be the state's SLP
against
in that, my lord, that matter, which your lordship is sitting for 2 p.m.
That is to be taken up on
Friday, coming Friday, day after tomorrow.
Day after. Oh, that OBC matter.
Yes.
It was fixed yesterday.
Yesterday, because Malayasia's Gawai was not well, so the court did not sit. So that is the reason it was day after tomorrow. He was admitted in hospital. So that's the reason.
So that whether that will be the submission from the.
That I do not know, but I know the facts. That is the reason that I'm telling your lordship.
It is fixed on Friday.
Friday, day after tomorrow.
So very good. We don't know whether that bench will continue or not. If we rise and sit, we will be taking up that list. You please contact.
We'll coordinate.
Like before us.
We'll coordinate.
Yes. Where is Mr. Sinara? Mr. Sinara, what is this? Your junior.
He's coming, my lord. I have called him and he's coming.
My lord, petitioner says that they have filed Barakpur court and case.
Are you his counsel? Are you her counsel? Huh? You haven't seen the papers?
No, counsel.
No, she is known to you.
Yes, sir.
Oh, I see. অর্ডারটা নিয়ে চলে যাবে। বলো 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 বলো
My lord, I shall advise this side Tapan Raipal, my lord, adequately and make him understand, my lord, the grave situation.
What you will advise? You are fighting his case, you are saying I will advise. Huh? He will listen to you. This sort of person should not be allowed to practice.
My lord, do not do this, my lord. This is my fallen head, my lord.
No, we are not sending you. We are sending him.
I understood, my lord, but not
This
my
is
lord.
very, we believe our counsels. You are our officers.
Previously, there was
Not in this matter, my lord, at least, my lord.
My lord. এখন 2025 থেকে মারধর করে নানা রকম
Yes, sir.
Yes, sir. What is your name?
My name is Tapan Roy.
Pardon?
My name is Tapan Roy. Elias Pal.
You are practicing since when?
Yes, my lord.
Since when are you practicing?
High Court me.
When? How many years?
2018.
2018. So you have obtained the signature of your wife to file this petition?
No. Oh.
Mr. Tapan Rai, we tell you, we have evidence against you.
No, my lord, false allegation.
So falsity you go and prove, we are referring you to the Bar Council. Go and prove your falsity. No, yes, we don't know. You have to go.
No, do not do this, my lord.
Go and save your certificate. We will make appropriate remarks in our order.
My lord, do not do this, my lord. For this time, my lord.
No. You will torture your wife and you will approach habeas corpus court. Money. Everything is money.
I'm being led by Mr. Sriram in online, senior advocate.
If it might please your lordship, if I am audible, Lords.
Yes, you are.
Lords, the application that has been presently filed is in the context of.
One moment, Mr. Sriram.
Yes, yes.
Special petition which was filed that came up on 15th, but since the Honorable Chief Justice of India was not sitting, the matter is slated on Friday.
Kept on 18th.
This Friday?
This Friday is my item number 13.
Doubt and out.
Item number 13.
Item number 13.
You are there in one of the matters?
Yes, my lord, I am there in two matters.
They have also
before the
filed the caveat.
We have filed caveat and we are appearing, my lord. Since it was not taken on 15th, it will be taken up on 18th. Because the Chief Justice was not available.
আমার বুধবার বুধবার শুক্রবার সামনের সপ্তাহে বৃহস্পতিবার ছাড়া সোম মঙ্গল বৃহস্পতি বল একটা করতে হবে কিছু করার নেই এটা তো ঝুলিয়ে রাখা বৃহস্পতি যেটা আমাদের হ্যাঁ বৃহস্পতিবার তাহলে এইটা বৃহস্পতিবার আমাদের Sriram.
My lords, I've been notified of the schedule of the proposed hearing. May I just indicate two circumstances which warranted the filing of this application. Lords, after the matter was dealt with in the manner your lordships disposed of the interlocutory application or passed the interim order on 17/6, there was an attempt made by the state of West Bengal to continue to implement their measures which had been a subject matter of challenge. And a contempt application was filed, and your lordships had indicated that it will have to be kept as a very tentative process subject to the conclusion of the legal proceedings, and that it shall not create any legal rights on any of the applicants, etc. Now, the schedule that was notified initially had a process of conclusion writ large on it as on the 1st July to 6th July of 2025. After that, there is an extension notification that is issued which extends the cutoff date for the conclusion of that preliminary process, which includes OBC-A and OBC-B, to 15th. And last evening, I'm instructed to state, subject to correction by the learned Advocate General, it's not an affidavit, it is indicated that the state has again put out in the public domain that the conclusion of that preliminary process is adjourned to 25th. I'm on 25th of July. I'm only indicating this. Your lordships have indicated in your lordship's judgment on 22/5/2024 as to what should happen to the pre-2010 classes. The state has undertaken that it will not conduct any recruitment in violation of that direction in its undertaking given in a contempt case or in another writ petition on 30th September. There is an adjudication by a learned judge of the Honorable High Court of Calcutta, which more or less is to the same effect. I am only saying that let the opportunities or the possibilities of the pre-2010 classes be published so that they can take alternative measures. Well, it's ultimately the publication of the merit list which I am seeking in pursuance of the compliance with your lordship's order dated 22/5/2024 or the sequitur arising from the 17/6/2025 order. In order that the students are not left in the lurch and they are not left scurrying to organize their educational opportunities if it is held that far, it is only subject to further process. Anyway, your lordships had caveated that, directed the state to caveat that. I'm only seeking your lordship's indulgence to look at the possibility of the chart or the merit list of the 7% reserved categories of the 66 classes prior to 2010. they will anyway will be subject to the vagaries of the further classes competing with it, depending on what happens in the Honorable Supreme Court. The original order is not stayed. Of course, we will reserve our submissions to the Supreme Court.
Mr. Sriram, are you saying that the 7% in the pre-existing classes as on 2010
Yes.
have not been allowed to participate in this admission process?
Millards, that is not what we are indicating. We have said that all of our applications have been accepted, merging our status to be in pursuance of the notifications which your lordships have stayed. We were a composite class then. We have been interspersed into classes A and B subject to the result of the legal process. Please confine our status to the unified composite OBC tag that we had.
Mr. Sriram, what I had a talk with my brother. They are saying that it is fixed on Friday. We will be sitting on the next Thursday. So if on the basis of the orders passed, we will hear you and we will dispose of our application.
Yes. Because assume
I have a respectful
stays the whole order. I mean, we are not presuming any, that's a possibility. If
I had a respectful submission.
One course will be taken. Assuming the Supreme Court does not interfere with our order and says let it be heard out, then another course will follow. As
Your lordships, I'm sorry, Param, may I just have?
I had a respectful submission to make. I'm sorry, Millards. Am I audible? Am I audible, Millards?
Yes, you are.
Yes.
Yes, Millards, I had a respectful submission to make, Millards. Millards, your lordship's interim order of 17 June 2025 is nothing but an extension or a concomitant, necessary concomitant of the 22nd May 24. Having failed to obtain a stay on the judgment dated 22nd May 2024, Millards, there is no question of them now arguing before the High Court, saying the decision of our appeal is 17 June 2025. Because your lordships will note specifically, on 30th September 2024 in my writ petition, that is 387 of 2024, the state gave an undertaking that it will only comply with, the state gave a specific undertaking that it will completely comply with your lordship's judgment of 22nd May 2024. That is qua reservation in government post. There can't be one test for Article 15 and one test for Article 16. So far as Article 16 is concerned, on 30th September 2024, they have already undertaken before your lordships that they will comply with your lordship's judgment. So far as reservations under Article 15 for educational institutions are concerned, Millards, there cannot be a different yardstick. Today, this ploy employed by the state, Millards, with all due respect, to say that they have appealed against this order is of no consequence. With all due respect, is of no consequence because 22nd May 24 order is not stayed. 30th September order, so far as reservation in post Article 16, they are saying they will comply with your lordship's direction. Number 3,
hold their breath.
Post your lordship, there is
what is the breach of undertaking?
One minute, Mr. Badr. 1 minute. Let me just finish my submission. Let me just finish my. I would only request my learned senior friend not interrupt me like this.
Are you interested to get the hearing before Friday? What interruption? You have started.
Because I'm not going to answer him. I'm not going to answer him. A learned parliamentarian will try to intersperse and I will try to interject. I have no problem.
Gas or whatever it may be.
That's okay, Millards. What I am submitting today, what I am submitting.
Parliamentarian. Don't say this.
No. Millards, today what I am submitting is this, Millards.
Don't say this. Parliamentarian. What do you think about yourself?
Millards, today what I am submitting is this,
Millards. What do you think about yourself? I will meet you on 18th. Come on, Supreme Court, and say all these things.
Millards, what I am saying is
what
this.
What do you think about yourself? Parliamentarian. You don't know.
What I am saying. Millards, what I am saying is this, Millards. Millards, I am addressing the court. Millards. I am only used to addressing the court. I can't fight multiple battles. I am only addressing the court.
No,
Millards, I am only saying this.
At the same time, you are hitting the lawyer, senior counsel. This is your senior advocate of Supreme Court.
Millards, I am only saying.
Senior advocate of Supreme Court.
No, listen, Mr. Parameshwar, let us say, we have been apprised that it is fixed on Friday. As Mr. Sriram was suggesting, that as regards, we are also troubled as regards stalling of the entire admission process and etc. Because ultimately the students would be the sufferer. So we, as it has been fixed and the list has been given, we find that it is fixed on Friday and hopefully it will be reached by the Supreme Court. So whatever, because you will be there before the Supreme Court also, naturally ventilating these things to the Mr. Sriram would be there. So we have expressed what we wanted and we have believed the state authorities, they have given undertaking to that effect under some terms and conditions. Whatever it is, the ultimate effect, we will decide after the Supreme Court considers it and comes back with an order. We will consider that and we will pass necessary orders and dispose of all the matters on that.
Very well, very well, very well, very well.
Just hold our horses, until Friday, and the next day we are fixing it on Thursday.
Very well.
The next Thursday, that is on what is the date? Tariki Pursh.
24th, no?
We are fixing it on 24th.
Yes.
We are equally concerned with the future of the students. In fact, that is more primary for us than anything else.
I'm grateful. Grateful.
Secondary, the future of the students is more important. Let us put our horses till 24th.
As you.
Just having heard learned counsel for the parties, it is apprised. Having heard learned counsel for the parties, it is apprised to court that the matter is fixed before the Honorable Supreme Court on Friday, Friday 18th July 2025. Full stop. That the matters before Supreme Court, that the applications and appeals before the Supreme Court filed by the state is fixed on the 18th of July 2025. Full stop. Paragraph. We deem it appropriate.
So not application, it's specially petitions.
It's specially fixed.
No, specially
petitions. Specially petitions are fixed so and so. Paragraph, since it would be inappropriate, full stop. We therefore need necessary to ensure to have these matters stand over until 24th July 2025.
24th, it will be at 2 p.m.
24th, 2.
Grateful.
All right, counsel.
Yes, I'm grateful.
Please give post title of the matters on which we will pass this order. There are many matters,
Yes, I'm giving.
1, 2, and 3. Right?
No, not
No,
one.
no.
Well, I'll give it. I'll give item now.
Now, this is connection. This is on WPA 111, no?
Yes, that's the item number 1 in which I have filed the interlocutory application.
আগের দিনের অর্ডারটার কস্ট টাইটেলটা দেখে নাও না, এটা তো একটা হলো।
ও আরো আগে
একটা,
আরো অনেক আগে। হ্যাঁ, আপনি
112
এইটা না, এইটা হচ্ছে
This order will be on item number 1.
No.
Item number
আজকে appellate side listটা একটু দেখো।
Because it'll have to be the other matter.
7 and item number 5 will also govern because state has preferred an appeal. They are of allied medical courses. They are suffering.
5 and 6.
5 and 6.
11।
Oh, on the matters on which we passed the 17 June order.
Yes.
This order we will be incorporating along with that cost.
Grateful. That be the appropriate course of action. Grateful.
নিয়ে অর্ডারটা ছাপিয়ে দিন।
11।
And that includes one more matter,
3 and 7.
Ahmadip or something like that. The
1,
court
3 and 7.
title and the matters on we pass the 17 June order, this order will go in that cost.
Yes.
Yes.
Only one kind.
Milord, only one matter is
24 তারিখ।
left over, Milord.
এইটা তো ওটার সাথে ঢুকেছে না, অরিজিনাল সাইডে এখানে আছে না?
আছে তো আজকে লিস্টে।
তো
ফাইভটা আলাদা তো।
অর্ডার ওটাতে আর দিতে হবে না, ওটা
এটা
24 তারিখ 2টোর সময় রেখে
5
দিলে।
আর 6 আপনি যেটা শো মেনশনের ঘরে করছেন।
1 থেকে 4 হচ্ছে
ফিউচারে আর
জাস্টিস শো মেনশনের ঘরে
5 থেকে।
এখানে না
আচ্ছা,
প্রিন্ট করে
এগুলো কারণ
অ্যাপেলেট সাইডেই along with OS matters করে দিয়ে দাও, এক
এটা
জায়গায়
বলতে
থাকবে সব
Point into
নাহলে
support
দুটো
করেছেন,
লিস্ট
ওটা যেটা বলছি।
হবে।
হ্যাঁ,
একই অর্ডার
8 9 থেকে
না 5
8
6 আমি 5
what is parliamentary?
এটাতে কোনো অর্ডার আছে?
in item number 1
আপনার
and
receipt আছে কিছু?
কিছু বলছেন
Although item 5 and 6
হ্যাঁ।
are not arising out of that order, but is earlier really interpretation of the earlier order. Can you take it also on 20?
Yes, the same list will appear.
Fine.
Same
it
list
will
will
come.
Deeply observed.
item
5 and 6, my lord, is for the
5 and
students. They have challenged. They have challenged.
Whatever it is understood. All the matters will be there. This order will go down in that cost item.
শুধু লড়ছি আর এখানে এসে
but in item 1 my lord I have made an application for being added as a party my lord can
Yeah, that will also come on that date.
Not served.
এইটাতে একটা অর্ডারই করে দিও না।
Mr. Banerjee, request all councils, let us be more cordial on the next
No,
day,
no.
I'm sure.
How can he?
It was unintentional, I'm sure. In fact, he gave you more respect
Well,
in addition to a senior council.
Become a parliamentarian, one is require
Maybe
a quality.
tomorrow you will meet in parliament.
To become a parliamentarian, one need a quality.
No, no,
And
no.
and
No, I don't dispute that, Millards. I don't dispute that at all.
Necessary.
It is not a coffee
I
house.
don't
People
dispute that at all.
এইটাই ছাপিয়ে দিও। Let this
It is not a coffee house to people sitting in the parliament. Fourth term member of parliament.
Definitely, Mr. Banerjee.
And one term a
As
member of
fixed at
25 years I have spent in the parliamentary democracy. I have to he listen all these things.
Not to it. It is not said in any way to insult.
What is this parliamentary? I am come here as an advocate, my lord. I don't have any other identity excepting lawyer. And till my last day, one of my wishes, till my last day, I should remain in this profession. This is my passion. This is my first thing.
Definitely.
We all wish the same. We all wish the same. We all wish the same.
You are what you can do. You don't have anything to do excepting this. What is
কমিশনের নাম স্টেট কমিশন
your
Regional side.
This is my appeal, Your Lordship. Your Lordship, I'm led by Mr. Bose. Your Lordship, however, Your Lordship, may I start with the facts, Your Lordship?
Led by Mr.
Mr. Saptanshu Basu, Your
Watch.
Lordship.
Start.
Yeah. Your Lordship, this matter relates to 33 Jagat Banerjee Ghat Road, Your Lordship. Your Lordship, this is a port premises. It was leased out to a company, which was also a government company, Burn Standard Company Limited. Now the Burn Standard Company has gone into liquidation. It has ceased to exist. And Your Lordship, Burn Standard Company at different, way back in 80s, had let out several portion of this premises to subtenants, Your Lordship. Your Lordship, the petitioner is also occupying one of the portions in 33 Jagat Banerjee Ghat Road. And Your Lordship, he is running his factory, MSME enterprise, here since 1983.
Land belongs to the Port Trust.
Your Lordship?
Land belongs to the
Yes,
port.
Your Lordship. It belongs to Port Trust.
Your Lordship. Sublessee.
Yes, Your Lordship.
Upon prior permission.
Not upon prior permission. Your Lordship, I'll come to that. Your Lordship, I just want to show that I have been in occupation since 1983 till 2025, Your Lordship. Your Lordship would kindly take up page 227 of the stay petition, Your Lordship. Your Lordship will find that Your Lordship, my electricity bill, Your Lordship, for 1980s and Your Lordship 2020. Your Lordship, I'm led by Mr. Basu. He's here, Your Lordship.
May I take over?
Yes.
I am the lessee of the original tenant. It is the original tenant. A proceeding under the PP Act was initiated. But I place, my lord, the last portion of the eviction order passed under the PP Act. But kindly take. Page 200, my lord, it will be little difficult for my lord to read. My lord, I am receiving, my lord, the copy. কোথায় আছে দেওয়া আছে কত পেজটা 200 I will not travel your lordship to the order. Kindly see the mark the date of the order 15th December 2000. Till today, my lord, order has not been executed. Till I am in possession. That I can show from the documents. What is the eviction order says? Kindly come to third page. Middle portion. The authority is observing, I cannot keep my mind closed. Has logically got it? I cannot keep my mind closed to the small but significant submission on behalf of the association, though the matter of granting direct tenancy is not coming under the purview of PP Act directly. I cannot put my back behind a burning question of livelihood of the persons associated with the business affairs of the members of the association who are under potential threat for eviction in the context of the socio-economic condition of our country. Therefore, the matter of granting direct tenancy to the member of the Tenants Welfare Association is existing occupant. Can you mark that? This is existing occupant only. Is being referred to the land manager, Calcutta Port Trust, for acting consideration in respect of the actual area in occupation of the members by such association. Let a certified copy of the order be served upon the Calcutta Port Trust to the land manager, Calcutta Port Trust, for action.
Who is the association?
There is an association, tenants association in that area. There are all the tenants from an association. The entire port authorities, the landlord, all the tenants from an association.
So this Messrs. Bond Standard was the original lessee.
Original lessee. We are under them.
So this was not executed for 25 years.
That is my another point of legal submission. I will come later.
But they did not take steps for eviction?
No, they cannot be in view of the policy that I also placed before my.
No, we want to know they
Yes,
did
yes.
not take. Then why did you
But
suddenly come up with this writ petition?
Now, my lord, the threat of eviction.
What they have done?
Threat of eviction? You go live. They put a padlock on my residence without anything on my business premises.
Padlock, what is this? It is an area of how many?
I have the room for my business. All tenants are there.
My business means
My business or
one as a member of the
association.
Oh.
That I will show to you, Lordship.
So you are in tenancy of one room.
One room.
How many rooms you are in here?
2 rooms, 1 set.
2 rooms?
2 rooms, 1 set.
1 acre.
Shed.
Maybe 1 acre.
So in this,
Area of the occupation.
My occupation is near about 1 acre.
1 acre.
Page 01, page 109, we have.
But that will come later. Quantification is come later.
And how much rent are you paying? How much rent are you paying? 10 rupees.
I have not paid anything. They have not asked for it.
Very-
I will come. I know. If my lord is with me, my lord will put me on terms. I know that. Let me place it. I think my lord will be satisfied of the case made out by this tenant. So my lord has seen the eviction order. But for the PP Act, I cannot be evicted. I am going to that extent. I am a subtenant. So my right extinguished along with the tenant. So there is an order of eviction passed in 2000. This 2000 order up till now has not been sought to be executed prior to that date when padlock was put in without any notice to me. Now, my lord, on the basis of this judgment, what subsequent things has happened, will also kindly look into that. Now, kindly come to page 203 of your lordships.
Yeah, too long.
203 will be not readable. Kindly come to 204.
What order you are wanting from us? Now today what?
The policy, my lord is want to make it short.
Yes. Yeah, as you
As
make
per-
it short, we also learn to make it short, Mr.
I always try to do it. But there is a policy that sitting occupants will be given a chance to outbid whatever the bidding of that premises. First refusal is with me.
Mr. Basu, that policy presupposes that you are a legal occupant.
No. Also existing occupant, not tenant. Can you come once?
Existing
Can you
occupant.
once look to that? Recorded the order in the PP Act. If I am legal occupant, my lord, no, nothing is required to be done. I am legal. If I am not legal, either lease expire or otherwise I am there.
Yes, show us the policy.
Kindly, my lord, seen that existing tenant, the existing occupant.
Where are you reading?
There is the order. I have handed over separately. Challenge করা।
That is 1 page of the order.
All one by one.
কি পড়তে ভগবান
কপিতে থাকতে দিয়ে
একটা কপি আপনি দেখাচ্ছি ছোট
আমারও গন্ডগোল তো সেই জন্য এটা আলাদা করে নিয়েছি
25 বছর
তোমরা যেটা দিচ্ছ একটা কপি দাও না
উল্টো পাল্টা আছে নিবি এটা নিবি আমারটাই নিয়ে নিবি
না না আপনারটা দিতে হবে
আর নেই
বলছে
এটা উল্টো পাল্টা
ভ্যালিডেশনটা উল্টো পাল্টা
একদম ভুলভাল হয় না
আমাদের না
কাজ না করতাম Right. Can we come to page 204?
204.
After the order passed by the PP authority, they asked us to have this legal lessee. The order said that. Kindly once look to the order, which have been handed over separately. Says the tenants association apply. I applied.
We didn't get that, Mr.
Well, last page of that order.
So you said
Therefore,
204.
my lord, is Justice Chakraborty asking for something.
Yes, 198.
98. Well, kindly see. Therefore, the matter of granting direct tenancy to the member of the Tenants Welfare Association is being referred to the land manager, Calcutta Port Trust, for active consideration in respect of the actual area in occupation by the members of such association. As a member of such association, I have applied. That is at page 204.
So when did you apply?
Well, it was applied in 2000 itself, 19 December 2000.
Yes, then what happened?
Then, my lord, sat tight over the matter. We give a reminder that your lordship will get at page 214. 214 is the policy. Now I am coming to the policy.
So you are not the sole sublessee. There are others.
There are others. We have applied all. So I am concerned, I am here before.
In their portion, no padlock given.
I have no knowledge.
Yes.
My landed friend can assist.
Yes, I will.
সবাইকে দিয়েছে specific query of my lord সবাইকে বন্ধ করে দিয়েছে
No, my lord, this particular who alleges to be the sublessee, my lord, is in occupation of a portion which was originally given by the port to Burn Standard. So, my lord, the eviction proceeding, the order of which is at page 195 onwards, that is eviction proceeding in respect of this land parcel.
Yes, yes.
And what he refers to is a letter written by the Tenant Welfare Association to the land manager for consideration.
আমি বলবো তাহলে my lord has asked something that I requested him to say.
So I have to answer it in my way. I cannot answer it in your way.
No, Bishop, are you putting it up for auction?
My lord?
What are your future plans? You put it up for auction?
No, I have to first take possession.
Right.
I have an order of eviction. The act contemplates the manner in which I am required to take possession. So that is what I have done. I have taken possession pursuant to the order of eviction.
Of 2000.
No, the litigations were pending. So my execution proceeding, which I had initiated in terms of the order of eviction, which was passed in 2000. So that execution, that eviction order, in terms of that eviction order, I have taken possession. And I have.
When was that order passed, Mr.? That was passed in 2000?
Yes.
So suddenly why you are putting padlock after 25
Padlock,
years?
I am enforcing, I am executing the eviction order.
After 25 years, that's what we are trying to understand.
But if your lordship will kindly see,
My lord,
let him conclude.
Very.
My lord, we have applied in terms of the order of the PP Act authority, estate officer. Then I applied for direct tenancy. That is the ordering portion. You can apply for direct tenancy and applied. In the meantime, my lord, page 214, this policy has been promulgated in terms of the order of the court. 214. Proposed policy on sitting occupants. So it is admitted, and I can also ascertain that we are on sitting occupant.
So 9 June.
Kindly come to paragraph 2. In terms of the order of the Honorable High Court at Calcutta, the then Secretary Minister of Shipping directed Kolkata Port Trust to frame a policy for sitting occupants. I will not trouble your lordship with the entirety. Kindly come to the next page. Paragraph 4. The committee met and discussed the issue on several occasions in Kolkata and also Haldia. The report of the committee is printed such and such in view of the fact that the land policy guidelines do not provide any scope to grant lease on nomination basis to non-government parties, the committee did not recommend collection of settlement fee as proposed in the earlier policy. The committee has recommended that the occupation enjoyed by the sitting occupants may be considered for regularization through tender cum auction procedure on lease license, as the case may be, in the following manner. Now kindly come to page 216, subparagraph B. The sitting occupants in Kolkata Port Trust structures as on 2nd January 2014 will also get first right of refusal in the tender comes auction for 11 months license provided. These things. Kindly next come to 217.
We
217.
Yes.
217, paragraph 5. Concurring with the recommendation of the committee, it is proposed that sitting occupants may be regularized in the manner enumerated in paragraph 4 above if they apply for regularization in such mode within the time to be indicated in the general notice. On receipt of the approval of board, such notice, including a specific time frame, which may be 6 months, may be issued. However, the sitting occupants who would not apply within the specific time will have to be evicted with due process of law. So we have applied. After this policy, my lord, was published, we gave another notice that will page 222.
Mr. Vasu, come to page 214 once.
214. My lord.
See from the third line, the definition of sitting occupants.
My lord.
Sitting occupants
Right.
are those who are in
Right.
possession of the premises.
Those who are in possession of the premises on the basis of certain arrangement, agreements with the recorded tenant. With the recorded tenant. Because, but without any direct approval tenancy relationship with KPOT. It is same to me, but not rank outsiders. Occupier who enters while encroaching the KPOT property. That is not there. So I, with the agreement with the tenant, I am there.
Show us the agreement. Where's your agreement with Burn Standard?
That what for the bar standard I am here. My lord is asking for the receipt of bar standard.
Yes, your arrangement with Burn Standard.
That is there. That is there. For the time being, kindly proceed on the basis that is there. I am coming under the definition of sitting occupant.
procedure.
I will.
এরকম ধারা তো নেই প্রভুজি এক্সিকিউশন this is the order. This order has been passed under section 5.
407 900. What is there under 4? 552.
eviction order to কি বলবো eviction order বলে দিতে ওটা গরিব লোক ওরা ডিরেক্ট এজেন্সির জন্য অ্যাপ্লাই করবে মেম্বার অফ দি টেনেন্টস ম্যাটার অফ ল্যান্ডিং টু মেম্বার অফ দি টেনেন্টস বলবো অ্যাসোসিয়েশনের আন্ডারে যেতে মেম্বার
But to open the padlock, no. My business, all properties are there. Everything is there. And I will taking a point.
What business you are running, Mr. Bas? What property is there? 1 acre.
It's an MSME enterprise, self-adhesive.
You are this Mr. Amar Chand Boda. He is he's a sole proprietor or what?
He was one of the director of Jyoti Coaters Private Limited. There is a judgment of Apex Court which says that PP Act is to expedite all rigors of law has to be applied, which includes, my lord, the limitation of execution.
Act doesn't provide for any timelines to execute.
No.
Neither do the rules.
No, absolutely no. But the Supreme Court says all rigors of laws will be applied. Only this PP Act only to facilitate the quick eviction of the government properties. So if all the law of the land is applied, then can it be conceived of that a decree which was passed 25 years back will be executed on, and other judgment said there, your lordship's court judgment is there that I should not be evicted prior to giving a first chance of refusal. Anything, many things, not anything. This I loosely submitted, I will cite those judgment. And the judgment of your lordship's court, I will have to show to your lordship. There, my lord, the extended policy has been quoted, and thereafter it said, unless the chance of first refusal is given to me, I should not be evicted.
Only if they are planning to dispose of the property on a further
Yes, that has
lease.
been done. Initially, that's why my learned friend mentioned this matter. They issued a tender.
Issued a tender?
Tender. Just why it doesn't matter.
Wait.
It could not be, my lord, produced, my lord, supplementary affidavit.
This is after the trial judge's order?
After the appeal was preferred. And he directed me the entire property was first refusal. That is not permissible. 100 acres of land has been, my lord. My occupation, that is division bench judgment. My occupation has to be given my first refusal. I cannot compete. If 100 kata is tender and my occupation is 450 square feet, I cannot be. I'll place the judgment of your lordship's court hereafter.
8th of July 25. Plot, location, period of lease, 30 বছরে দিয়ে দেবে। কবে বিট করে
এটাই পেয়েছি। আমার একটা বাবার মামলা
সবাই এত কথা বলে রিটার্নেবল করেছিল
4 weeks position change. Padlock is open. Ultimately, they have taken steps for eviction. The entire land will be now put to auction.
No, that cannot be. That I want to show to you.
Show us that how can you prevent auctioning of the entire land?
Yeah, I cannot prevent, but so for my part, he has to assess separately.
Assessment for what reason?
Let me place the judgment. This is a judgment delivered.
No, that is what the single judge has done. That you come with your affidavit, we will consider that
In the
4
meantime,
weeks.
padlock has been put in. My entire
Let it continue till 4 weeks. Padlock because they
my entire business stalled. The raw materials are there.
What raw materials? We don't find any description. Moreover, this auction is not pertaining to your.
Then kindly allow me to place this judgment.
About
This is the entire judgment is based on this, my entire argument. So this is reported in 2021, 2022 SCC online 2768.
SCC online
2768.
Supreme Court, High Court, সেটা বলো।
Calcutta.
Calcutta. Cal কত?
2768.
Auctionটা
Just show your lordship one paragraph from his writ petition. Thereafter, your lordship considers. But kindly take the writ petition which starts at page 55. The first para starts at page 55 of the stay application. And my lord, kindly take para 8 at page 58.
Yes.
Para 8 at page 58. Petitioner number 1 had obtained the said tenancy to one Agarwal Iron Trading Company, who was a direct tenant under the Burn Standard. So they are a subtenant under an unauthorized subtenant. So the subtenant was Agarwal Trading Company. So Agarwal Trading Company appears to have let out to them. So that first paragraph of the land policy guideline, which was pointed out by Mr. Basu, which starts
sitting
at
occupants.
Yes, sitting occupant land policy guideline, which policy was never applied.
From member submission on behalf of the association. Matter of granting is not coming under the purview. I cannot put my back behind a burning question of livelihood associated members of the association who are under potential threat of eviction. Paragraph, Mr. Vasu.
Kindly come to paragraph 9. In spite of this fact, my lord, who is now sought to be make out a case by Mr. Bose, that has been also answered here. It has not been clearly spelled out in the writ petition how and in whom the petitioners were inducted in the premises in question. In paragraph 4 of the writ petitioner, vaguely it has been asserted that it was inducted into the demarcated portion of the premises on such and such Forsod Road, however, Howrah by the recorded lessee, Binani Metal, and thereafter such and such and have been paying rent for last 20 years. In paragraph 11 of the writ petition, again it is averred that the petitioner are in occupation of the said premises for the last 20 years with an arrangement with the recorded tenant Binani Metals without any supporting documents. The appellants in their application for stay in connection with these appeals suggested that after the said order of eviction, several unsuccessful attempts were made to evict the writ petitioner. Here it is not appearing. The writ petitioner suggested that they had been insisting on payment of outstanding dues, including interest in respect of the proportionate area of the subject land and against regularization and being inducted as a tenant as per the SPMQ norms. By way of several letters, the writ petitioner submitted several checks from the time to time, rent, municipal tax, etc. and such and such. The writ petitioner prayer. Kindly come to paragraph 14. By the order impugned, the learned single judge observed that indisputably the petitioners have been occupying the land in question for long. They suffered an order of eviction. The notice of the first right of refusal does not insist of taking physical possession of the property. But this is not the correct, that first physical possession, then tender. Possession of the purpose. In view of that, the authority under no circumstances can insist on the delivery of physical possession. The learned judge was of the view that the KAPT should be directed to initiate the tender process in terms of the said notice for the first right of refusal. The learned single judge observed that the authority would be at liberty to take symbolic possession, paper possession, the land from the petitioners in terms of the said notice of circular. The petitioners should have the right to participate in the tender with the first right of refusal, subject to having cleared all their dues, including interest. In the event the petitioners establish themselves as the highest bidder in that auction, their possession in respect of the property should be regularized immediately. The KOPT has restrained from creating any third-party interest in the respect of the property in question till the completion of the tender process. It was further observed that if the petitioner failed to exercise the right of first refusal in the tender process for any reason whatsoever, the order of eviction would be executed by evicting the petitioner from the property. Then, my lord, I am skipping over this portion. Kindly come to paragraph 19. The notice was quoted. Paragraph 28.
এটা তুমি ম্যাচ করতে পারলে যদিও তুমি L1 বিটা yes
now let us see what the court decided. Kindly come to paragraph 28.
28
This part is may not be relevant for our part. From the facts narrated, I just got it. From the facts narrated above and from the submission of the respective parties, the only issue that arises for consideration is whether the writ petitioner bring the unauthorized occupants like me of the relevant premises are covered under the said notice, and if so, whether they should vacate the said premises before the auction takes place. It is necessary to quote the said notice. Kindly read the notice. KOPT has decided to grant first right of refusal to the sitting occupants. That again it is quoted as on 2nd January 2014 in the tendering process to be taken up for allotment of the particular land structure of Kolkata dock system. Well, then it is quoted or such and such. 2. The occupants enjoyed by sitting occupants, the occupation enjoyed by the sitting occupants may be considered for allotment through tender cum auction process of lease license as the case may be in the following manner. The sitting occupants of the land as on 2nd January 2014 will get first right of refusal in the tender cum auction of lease license provided. The sitting occupants remedy all breaches including non-payment of outstanding dues at applicable rate not less than prevailing SOR and interest before commencement of the tender cum auction process. The valuation of structure, if any, has to be paid to KOPT by the successful bidder. Since the structure belongs to KOPT or will belong to KOPT after taking over symbolic and paper possession. The sitting occupants withdraw all court cases and reimburse the legal cost incurred by the KOPT. Dues of recorded tenant will include on-time damages for unauthorized subletting equivalent to rent charges or such and such. If there is more than one sitting occupant, lease license in respect of the areas occupied by the respective sitting occupants will be processed for willing occupants only. The recovery of dues on pro rata basis, provided each space has separate access. Here the entire process cannot be charged on me. Sitting occupants on KOPT structure as on 2nd January 2014 will also get first right of refusal in the tender cum auction for 11 months license fee. The sitting occupants remedy all breaches including non-payment. The sitting occupants withdraw all court cases. Second is not, it can come to 3. The interested sitting occupants are requested to contact the following officers for understand the scheme before submitting the application. 30. The said notice of first right of refusal was issued with the object to expedite the commercial exploitation of the land belonging to the KOPT, in respect of which they have obtained a decree of eviction, but the possession thereof was in the unauthorized occupant sitting on the said land. The notification entails a limited right to such an unauthorized occupant sitting on the said land or property as on 2nd January 2014 to participate in the auction with the right to first right of refusal. A bare reading of the aforesaid notice, in particular paragraph 2 thereof, does not support the contention of Mr. Dotto that the said notification only applies to sitting occupants as on 2nd January 2014, against whom an eviction decree was passed. And since the eviction decree was passed against them only on November 30, 2016, they could not avail the benefit of the such and such. This is also not necessary for our purpose. Now, 36. Then 36. Again, it has to be noticed that paragraph 1C of the said notification does not provide for any additional condition to come with the scope of the said notice for the first right of refusal. It provides for the manner in which KOPT requires to take possession of the land in question before the allotment of the said land in the auction. The said paragraph 1C makes it clear that before the allotment by way of a tender process, SMPK may take the symbolic paper possession from the original recorded license as and way by of execution of the eviction decree, or it may take paper possession of the relevant land structure under any mutual agreement. Therefore, the applicants, in my view, cannot insist on vacating or delivery of the physical possession of the relevant land or property before the same is allotted by way of auction. The first right of refusal in the tender cum auction is further subject to the compliance of the condition enumerated in paragraph 2 of the said notice. It has also been stand that the writ petitioner that they are willing to comply with the condition under paragraph 2 of the said notice. I may hasten to add that though the said notice to first charge of refusal indicates that to avail the benefit of the same, an authorized occupant needs to apply within 6 months from the date of publication of the notice. Neither the applicants nor the writ petitioners indicated the date of publication of the notice. The applicants have not taken any ground that the said notification is so not for force of such and such. In view of the above, I am of the opinion that the writ petitioner do not come within the purview of the said notice of first right of refusal, cannot insist on vacating the said premises as a condition precedent to avail the benefit that flows from the said notice. This is, my lord, the one honorable judge, Justice Banerjee, my lord, concurred with this. Lord, if you lord, can come to 41, yes, so I am thankful. The order of the learned single judge therefore does not call for any interference, and the same is accordingly upheld. It is only added that the KOPT will be at liberty to initiate the auction process at their earliest upon taking the symbolic paper possession of the relevant premises from the writ petitioner. It is clarified that in the event the writ petitioner do not become successful in the auction, they will vacate the property under their occupation within 48 hours of completion of the auction. Otherwise, this KOPT will take at liberty to recover the possession from them by executing the eviction order.
Page 41, paragraph 41 is against you.
No, may I read once again? The order of the learned signature therefore does not call for interference.
It is only added that. It is only added that.
Yes, it is only added that this KOPT will be at liberty to initiate the auction process at their earliest upon taking the symbolic paper possession. Then it is clarified that in the event the writ petitioner do not become successful in the auction, they will vacate the property under their occupation within 48 hours.
Your grievances now, I would have also participated. I would have also participated had my portion been put up for auction.
That's the judgment.
So that in case this is that judgment does not covers this fact scenario. Herein, Your occupation is 1 acre. They have evicted some persons, they have put a padlock and they are putting up the entire property on action. Now tell us, how can we?
I say that you cannot take up physical possession. Here, all along the judgment says, for auction you take paper possession and auction. I have a right of first charge, first refusal. Am I clear to my lord? Am I clear to my lord?
That auction would be an auction pertaining exclusively of your property. But in this case, it is not so.
That's why, my lord, this
That line is not there.
my lord, this part is there. It is, if there is more than one sitting occupant, I have read that, license in respect of the areas occupied by the respective sitting occupants will be processed for willing occupants only on recovery of dues on pro rata basis, provided each space is separate access.
Page, paragraph.
This is policy, my lord.
Paragraph.
Just kindly come to paragraph 29, last second page. Paragraph 29. Oh, I should have given emphasis. Third.
Of that policy?
Yes, that is quoted in the judgment. Paragraph 29, kindly come to the judgment. Next page, last condition. If there is more than one sitting occupant. It covers, well, I should have given emphasis while I was reading that. Otherwise, it is unworkable. Right policy, my lord, according to my humble reading. If somebody is occupying 500 square feet in an 1 acre land and 1 acre is, my lord, auctioned, then he cannot, this policy will not be applicable unless this clause is there. This clause is clear here.
But how can we ask them to segregate your portion from the land which is being put up for auction, Mr. Basu? There has to be a reasonable solution.
Yes. Kindly come to page 222.
222.
I have mentioned which portion I am in occupation. They are also having knowledge of that. The subject we have categorically said what is in my occupation. I repeat, my lord, otherwise policy become unworkable.
Yes, Mr. Basu.
No, may I conclude?
152
Another map is also there. They know, they are the landlord. They know what is there. They're supposed to know. And I also indicated. No, my lord, what I was submitting at the
Yes.
Now, my lord, at the outset I was submitting, my lord, the decree of 2000. Decree or order, whatever, my lord said. And the PP Act, there is no provision for
There's no
execution.
limitation.
No provision for execution, kick out. I say this kicking out is an execution. You allowed the decree to slip. And the Supreme Court is saying that PP Act is an act for expeditious disposal only. You cannot give in a go-by to all laws in India.
Yes.
That is reported in, my lord, 2019-20 Supreme Court cases, 705. 2019-20 Supreme Court cases, 705, paragraph 49. Only one paragraph I will show to your lordship. A 3 judges bench also relied upon. Your lordship can look into that also. At this stage, we consider apposite to take note of the Constitution bench decision of this court, wherein the court, after examining and upholding the constitutional validity of the PP Act, reiterated the view taken by this court in an earlier decision that the PP Act does not create any new right the PP Act does not create any new right of eviction, but it only creates a remedy for a right which already exists under the general law. In other words, it was held that it only provides a remedy which is speedier than the remedy of a suit under the general law. So by PP Act, you cannot do whatever you like. It is for expeditious disposal, expeditious eviction. You allowed this decree to be slept for 25 years. Well, another limitation act, my lord knows. 12 years is a limitation. Had it been a decree of a court, you cannot execute it beyond 12 years. Keeping in judgment in lordship's mind, if your lordship kindly think whether a judgment or a decree of a PP Act allowed to be executed after 25 years.
Yes.
But at the same time, my lord, I cannot say that only, my lord, the execution is barred by limitation. I should be there all along. That's why the policy came into force. This policy says if you are a sitting occupant and a decree is against you, no time limit. And the time limit prescribed in the rules, my lord, has been extended. There is 99, my lord.
Remove the bedroom. Where is this notice of 29th May?
That is the date of possession.
Notice টা 29th May.
They pasted the position.
Page?
They, my lord, কোথায় আছে সেটা? Page 194. They pasted on the outer one.
Page
194. And my lord, I'm sorry, my lord, if you point out, my lord will not find that in terms of the decree of 2000, they are taking possession.
In terms of final order of eviction.
That's all. The date has not been given.
15th of.
Oh, sorry. Then what it is apparent. 15 December 2000. They are taking possession in 2025.
All right.
That's
So, boss, we have another fixed appellate side matter.
Fine.
So, can you come back tomorrow?
Tomorrow?
Tomorrow, কালকে আমাদের কোনো বেঞ্চ আছে নাকি অরিজিনাল সাইড? আর অরিজিনাল সাইড
Very well. Very well.
My lord, all other
22nd, 3:15.
22nd or
That we are arranging, we will be sitting one day every week taking up original side matter. We are rearranging our list. Please wait for this week. We will publish in our list.
22nd.
Heard Mr. Saptangshu Basudan, senior advocate. We have a fixed pattern. Where is your other side? He has come. Your senior has come.
Lordship, senior is on his way, Lordship. Just a minute, Lordship. He may start, Lordship.
My lord. Lord. From the order itself, two facts will come. Execution stage of an order of a detaining authority can be interfered or not, and if so, in what extent? This is number one. Number two, whether the detention authority's apprehension relating to a person will be released on bail, reason for invoking preventive detention or not. The Supreme Court said if the detaining authority has a reason to believe the person may be released on bail, that itself is a ground for the prevention of detention. In invoking preventive detention.
If the person who is?
If the apprehension of the investigating agency that the person may be released on bail, that itself is a ground for detaining him under the preventive detention under PIT and DPS. Well, I shall satisfy your lordship. This is number one.
Assist your lordship, the writ is pending, my lord, not been disposed of. By the
We have told him in the morning, writ is pending. At that time, you were not.
No, my lord, I'm sorry, my lord.
This is number one. And second, your lordship will find whether at the pre-execution stage,
Preventive detention.
of preventive detention, the order of the detaining authority can be interfered or not.
Thirdly, how could they obtain an order of preventive detention without it being served upon?
And my lord, thirdly, how they have obtained the order of preventive detention without being served upon them.
It has not yet been executed.
It has not been executed. Your lordships knows the law of preventive detention says that it flows from Article 22(3). It says, my lord, as soon as the detention order is being served on the accused, from that time only, my lord, preventive detention will start.
After detention.
And after detention, my lord, kindly your lordships knows better than me. If your lordship can see Article 22 once.
Constitution to the
Then I shall, my lord, place the, my lord, the Pitt NDPS Act.
No, Mr. Mojumdar, first satisfy us.
Yes.
Come to the
My
order.
lord, I got it, my lord. Your lordship's query, the report was supposed to be filed. What report? My lord, these reports, it's a confidential in nature. It cannot be given to any other person, even to the accused. That the, my lord, the act says.
Only after his detention.
And only after the detention, this, my lord, the starts, then this copy should be relied on.
He is not in custody with right.
That was not the learned single judge.
Yes, my lord, kindly come to the order once, my lord. Kindly come to the page 54, annexure P2.
Yes.
The petitioner aggrieved by the order dated 16 May 2024. My lord, first they have to satisfy before your lordship's court how they have obtained this order.
All right,
Lord,
that you have argued, we shall take
yes, my lord, kindly see the order once first, page 50.
Yes.
Your right hand side, your lordship will find secret document. My lord, got it?
No, no, you were placing the order.
Yes, first, my lord, 50, your lordship kindly come, the order. Then I shall come to the order.
Yes.
Yes, my lord, kindly see right hand side, secret.
Right hand side.
Page 50.
Top right.
Oh,
top right. Then the order, my lord, for preventive detention in terms of section 3, subclause 1 of the preventive detention of illicit traffic of narcotic drugs. My lord, got it?
To be detained and kept.
And my lord, kindly see the language. Kindly see the language. My lord, first para, 3 line from the bottom. The respect of the person known as Raghunath Kumar, son of so-and-so, with a view to preventing him for engaging in illicit trafficking of narcotic drug in future if necessary to make the following order. Now, therefore, in exercise of the power conferred under section 3 subclause 1 of the Prevention of Illicit Detection Narcotic Supply Act, I am directed Raghunath Kumar so-and-so be detained and kept in Jaipur Central Jail, Rajasthan.
Right now is in.
So, right now, the person, my lord, is in Presidency Jail.
In connection with.
In connection with, my lord, NDPS, there are 6 cases pending against him. All are NDPS cases. This person, through the dark web, he, my lord, contained the narcotic substance from various parts of, my lord, the world and supply it to the, my lord, the general public. This is the allegation against him. And, my lord, we have the secret information. I shall place it before your lordship. It's a confidential in nature that this person, when he was inside the jail, he was, my lord, his activities was in and around Calcutta, Bihar and Odisha, this circle, inside the jail. And he was operating from jail itself. And once he was released on bail, he chose to not to furnish the bail bond. So that he can stay in Presidency Jail.
Because only other case in which he is in custody is the Delhi jail.
But this is a case of national importance. Blood, your lordship knows better than us. Blood, war against narcotic substance, it's a national importance now. And that is the reason the appropriate authority, blood, on as per our recommendation, Milord, we are the Milord, the narcotic NCB, Milord, we are the sponsoring agency. As per our recommendation, Milord, kindly see the recommendation once, Milord, it is there in the file.
It is only for your lordship.
It is only for your lordship's perusal, Milord.
Because since they are not executed,
as because it has not been executed as of now, so Milord, we cannot give it to the accused.
Keep it all right. Keep it with you. Now, this order was dated 16th May 25.
16th May 25. Now, just now, Milord, kindly come to 49, the previous page. Milord, this order was communicated to various authority by the, my lord, the Finance Department, Deputy Secretary, Government of India, Finance Department. My lord, kindly see it. Endorsement of detention order dated 16/5/2025 in respect of Raghunath Kumar, son of Swanso, under section 3(1) of P10 Act 1980, the additional director of NCB Kolkata Zonal Unit with request to take immediate necessary action to serve the detention order upon the detainee Raghunath Kumar Swanso. Number 1. B. 3 more copies of detention order are also sent herewith. Out of this, 1 copy marked with the detainee may be served on him.
Show us the relevant portion, Mr.
Yes. G is the relevant. Well, kindly see.
Yes.
It may also ensure that the compliance of the provision of P10 Act 1988, the grounds of detention and relied on document and the list thereof are served upon the detainee simultaneously, repeat simultaneously, within 5 days from the date of execution of the detention order. My lord, kindly mark it, my lord. So once the detention order is being executed, then only the ground.
Prior to execution, the detention order.
No, it's not. No, it cannot be served. It cannot. That is the settled law. My lord, I shall place it. Only one judgment I shall place it before your lordship. It cannot be served. It's a secret document. My lord, they have to explain.
Where does the statute provide for that? Does
Yes,
the
my lord,
statute provide for
yes,
that?
yes, my lord, of course. Kindly see it, my lord.
No, statute is constitution also.
Sir, please, don't be so excited.
My lord, it is in the
You
constitution.
will get excited.
My lord, it is in the constitution itself and also the act itself.
That a detention order cannot be served.
Cannot be served. My lord, kindly see section 5.
So when will it be served then? After it's
execution,
taken to detention.
Once he will shift to, my lord, the Rajasthan jail. That is the purpose of preventive detention. My lord, it is this, my lord, act or the, my lord, the constitution.
Please show us that
Yes.
provision. It cannot be served, that portion.
Okay, my lord, first, my lord, kindly take the constitution once, then your lordship.
Constitution, yes.
My lord, Article 22.
He would be made known the reasons of detention.
Yes.
Right now.
My lord, kindly turn to, my lord, Article 22,
Yeah.
Sub-Article 5. My lord, got it?
Yes.
When any person is detained in pursuance of an order made under law providing for preventive detention, the authority making such order shall, as soon as may be communicated to such person on the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. So when any person detained in pursuance of an order, so it will come once he is detained, and then under any law providing for preventive detention, the authority making such order as soon as may be communicated a person grounds on which the order shall be made and afford him for the earlier opportunity against him. Now, my lord, kindly turn to the act. P10 DPS Act. Section 3, subsection, my lord, 3. It has been, my lord, the constitution, the provision of constitution has been quoted, and that then the law was, my lord, defaulted. My lord, got it? For the purpose of clause 5 of Article 22 of the Constitution, the communication to a person detained. My lord, 3.
Yes.
Subclause 3. The purpose of subclause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention. Blood got it? After the detention, but ordinarily not less than 5 days. Blood, once the person is detained, after 5 days, the grounds for detention and the reason for detention will be provided to him. And milords, over here in this case, he was not detained in pursuance of the detention order as of now. Milord, his detention will start once he is being shifted from Presidency Correctional Home to the Rajasthan Correctional Home. then only my lord, the detention order will come into force. At present, the person is in custody in connection with my lord, a case by NCB in Calcutta. And he was detained a case, NCB case from Delhi. In these two cases, he has been detained here. He is in custody.
Now, when did he get that bail that he has annexed? Page.
Yes, my lord, after the my lord, the detention order.
So that was, you did not put it to the notice of the court that detention order has, because the order of the court was on 19th June.
It cannot be. It can be served upon the detainee once the detention, my lord, be effected. Then only this order can be served. The law says otherwise.
The detention, that joint secretary order was of 16th May.
Yes.
So you, 16th May, you are making arrangement now on the basis of our order
Not
passed 3
now.
months ago.
No. My lord, what we did on 16th May only, it was communicated to the various officials of the state of West Bengal as well as the state of Rajasthan, the chief secretary and all, and prison. And my lord, it's a.
Sir Mujumdar, it is so serious. You yourself have slept for two months.
Where?
June, July.
No.
25th, 19th of May was the order of preventive detention.
Yes.
You say it was communicated to these other stakeholders. But we will not communicate to him since in view of this provision.
Yes.
But what did you do for 2 months? Why only tomorrow you are taking?
State authority was sitting tight on it because they have to do the requisite security arrangement, because these persons cannot be transported by 2 or 3 persons. Security protocol has to be maintained. Kindly see this document, how it has to be maintained. These are in sealed envelope. Your lordship will understand that. Kindly see these 2 documents.
Last page to show that one. Please go on.
Kindly turn to page 27. These are confidential documents, my lord. Your lordship kindly peruse it and my lord, put it in a sealed envelope. The communication. My lord, got it? Page 27, my lord, kindly see. To whom it was communicated?
And by whom?
And by whom? As because the jail, it comes.
Yes.
As because the jail authority comes under the government of West Bengal, so they have to take a suitable date. And why this has been mentioned here in page 27. D.
Yes. Anything else, Mr. Majumdar?
Yes. Now, my lord, 2 judgment I shall show your lordship. Only 2 judgment. What is the law relating to preventive detention? And my lord, I told your lordship 2 aspects I shall apprise your
Mr.
lordship.
Majumdar, then we have to decide the matter finally at this stage. You are arguing on that issue. So today, if we vacate the protection which has been given, the writ petition itself becomes infructuous. Nothing remains in the writ. Once we set aside, once we stay the operation of his blood.
I am saying, my lord, the petition itself is not maintainable because on the first threshold, they have to, my lord, convince your lordship court how they got this document.
Exactly. You are wanting from us that today you dismiss the writ petition itself, which the learned single judge has made it returnable for hearing. Our question to you is 16th of May, all right, detention, he cannot be given, etc. Good, bad, indifferent, his lordship has been asked to pass an order, since on the basis of if it was so serious, why the NCB was not at that time? You ought to have taken appropriate steps.
We have said my lord, only this thing. Kindly see, my lord, the order passed by the court once. What is the reasoning, my lord? 2. It appears the petitioner has been granted bail by a coordinate bench of this court on 19 June so and so, wherein the court recorded the petitioner was custody is about 2 years, 4 months, and no recovery was made from him. The trial could not be concluded for the petitioner. It is submitted there is no evidence against the petitioner, and the impugned order authority is trying to circumvent the provision of law. Then, my lord, the learned advocate representing the respondent authority seeks time to file a report. My lord, this report was supposed to confirm, my lord, this confidential document, which cannot be given to the accused.
That is your argument. Please come to the order, page 51, the bail order.
My lord, bail order has nothing to do. My lord, the Supreme Court is saying, my lord, it is a ground. The person will be released on bail. That itself is a ground for preventive detention order. My lord, just one para I shall rely on your lordship. And it has not been executed as of now.
It's 53 it is true that no recovery was made. We will come to this. Please kindly come to page 52 first. What is the submission of NCB? Learned counsel opposes the bail prayer that he is the main organizer. He used to order narcotic drug for foreign thereafter associates. Now, he further submits. It is true that no recovery was made from the present petitioner in connection with the present case, but he was running the drug cartel in India. He used to book parcels through darknet and used to pay through cryptocurrency. You admit that nothing was recovered from him.
No.
You submitted, court considered, released him on bail. Have you taken any steps? The 19th of June, have you taken any steps for cancellation of
Well,
this?
again, I'm telling you, lordships, the bail order has nothing to do with the preventive detention.
No, Mr. Mojumdar, there are judgments which says that it would be your first responsibility to, that would be a path. You cancel the bail, you take him into
Well,
custody.
kindly one para, my lord, may I place your lordship? Just one para, my lord, para 17 of this judgment. Para 17.
17.
And so far as illicit trafficking is concerned, the recovery is not a mandate. Now, my lord, kindly see para 17. Now, applying the law laid down by this court, referred in herein above, to the facts of the case hand and considering the ground and the various circumstances noted in the detaining authority, we are satisfied that the detention orders cannot be quashed on the ground. It is to be noted that detainees has a granted bail by the court on the very day the orders of detention was quashed by the High Court. Therefore, the apprehension in mind that detention authority that the detainees are likely to be released on bail as well as founded and forfeited. Therefore, the High Court has fallen in error in quashing and set-asiding the detention order on the ground there is a clear lapse and failure on the part of the detaining authority to examine and consider the germane and relevant question relating to the imminent possibility of the detainee being released on bail while recording its satisfaction of passing the detention order. But the similar circumstances happen in this case also. But the person was in custody and the detention order was passed. But on the day, when the detention order was set aside, on the very day, the person was released on bail. So one of the ground of the detention authority was that we are apprehending he might be released on bail. That is the reason, the detention order was obtained. The Supreme Court said, the bail has nothing to do with the detention order. Rather, the person will grant bail. That itself is a ground for detention order.
Yes, Mr. Bhattacharya.
Well, first of all, the grievance of my learned friend, what I have found from the impugned order is so far circulation is concerned. If your lordship sees the impugned order, my lord, of the honorable single judge, well, it's only whatever argument he has made that may be restricted to paragraph 5, that the report should not be circulated, because that is confidential.
92 judgment.
No, but so far that part is concerned, but I'll leave it to your lordship's discretion. But my writ is pending. I'm sorry, my lord.
বলছে যে ওই রিপোর্টটা যেটা অ্যাডভোকেট ফাইল করতেছে that contains confidential documents that could not have been circulated, that cannot be circulated. The report will be read and circulated. Not necessarily it's confidential. That is his argument.
Is this the report that is sought for by the learned single judge to be circulated?
Yes, my lord, this is a confidential report. It cannot be given in for the statute itself. We cannot give it to the, my lord, the accused.
At this stage. So that part may be expunged.
Once,
I dispute, my lord.
my lord, one and second thing, my lord, kindly consider one thing, whether, my lord, the detention order, until and unless it has been executed, whether this can be challenged or not, my lord, and if
That is for the single judge to
just one para, my lord, just one para, my lord, from the Supreme Court judgment, I shall place it. And my lord, how they have obtained this document, because they have to make a averment, how they obtained this document, that is mandatory. The Supreme Court is saying that there is not a single averment saying that how they obtained this document in the writ petition.
Secret confidential document.
It's a secret confidential document. It, my lord, how they have obtained, your lordship will find from the writ petition, this document is a WhatsApp copy. Your lordship will find that. And there is no averment to the effect in the writ petition. But kindly see this judgment.
That point, I'm sorry, my lord.
So, Mr. Bhattacharya, what is your argument? Tell us your argument. Many allegations have been leveled against.
But the first of all, my argument will be before your lordship, my lord, this is a premature one, my lord, because my writ is pending. Now, whatever argument learned counsel for the appellant, my lord, places before your lordship, the argument is that what is your locus, how did you obtain the document? My lord, nothing was argued before the learned single judge when the matter was heard. So the point of maintainability should be first argued before the honorable single judge, my lord, who is in active session of the matter. Now, only on the ground that, look, they have not taken the point of maintainability there. Now, they file an appeal saying that, look, your writ petition should not have been admitted at all. When before the honorable single judge, their prayer that was that, my lord, we will file a report. That's paragraph 4. That give me time, I will file a report. Now, what the sum and substance of the argument I have understood here, that there are confidential information, so there is a confidentiality to be maintained. So therefore, so far the circulation is concerned, that they can definitely argue before the honorable single judge, or your lordship may pass necessary order so far para 5 is concerned. Otherwise, my writ is pending there. It's only an interim order.
No, para 5, no, para 8. What do you have to say about para 8?
The para 8 is that, if para 8 is not there, the writ will be infructuous. I tell your lordship, the judgment which was placed before your lordship has no bearing, my lord. I tell your lordship why. In Union of India versus Jalan,
once that 16th May is given to you, then you have ways to challenge it. And then, you can take necessary steps, and then the advisory board and
I'm obliged. There are two ways of looking at it.
So, how can the writ, why would the writ become infructuous? Or why would your cause of action doesn't go, even if the writ
I tell you, the difficulty is on, my lord, what I will say, the practicality where I'm situated at that point of time. It's like, my lord, a person is fighting a case, being in custody for bail or for antecedent bail. This is the subtle difference. My lord, what Mr. Mojumdar has placed, those provisions, my lord, those provisions speak. Once the order is executed, then within 5 days, you have to do such and such, such and such. But there is no prohibition that you cannot serve it beforehand. And what they have done, my lord, not placed before your lordship, is the trial court's order. Your lordships have seen the order of bail, my lord, granted by the honorable single judge, my lord. My lord, this was prior to that, my lord. Seize this order.
My lord, bail order has nothing to do with
it's not bail order, seize the order, my lord.
Nothing to do
which was never placed before the honorable single judge at the time of bail, nor before your lordship, in connection with the same proceeding. But if I may place, my lord, record is put up today. Received 2 letters having similar prayers along with a copy of the order of Joint Secretary Government of India endorsing by such and such Ministry of Finance from the Superintendent of Presidency Collectional Home, Alipur, with a prayer for necessary permission for shifting the accused such and such from Presidency Correctional Home to Jaipur. peruse the prayer. Since trial is going on in this case in full swing, the physical presence of the accused is required to enable their learned lawyers to get proper instruction for making suitable defense to ensure to achieve the purpose of fair trial. However, the superintendent of Residency Collectional Home, Alipur, is directed to produce the accused named above before the concerned authorities in virtual mode, as and when required positively, such and such, for production and appearance of the accused persons in respect of defreezing of the bank account and for trial. Now, this order was passed on, my lord, 9th of June 2025. The bail order was passed, my lord, on, I just give the date, my lord, on, my lord, 19th June 2025. This order was never brought to the notice of the Honorable Single Judge. A. So,
We'll bring it.
now, before your lordship also in the appeal, subject to correction by your lordships, my lord, there is no whisper about that their prayer was judicially turned down. And this order has not been impugned anywhere till date, my lord. And
the bail, but he
did not. It is they have annexed in their petition. He did not furnish the bail bond.
well, that goes in my favor. So there is no apprehension.
Wanted to stay in
Kolkata.
presidency.
No, my lord, I could not file the bail bonds, my lord, which is, my lord, kindly appreciate the foremost precondition for preventive
Tell us
detention is
in-
that I will flee away.
Where is that order? You were granted bail, but you did not furnish bail bonds.
My lord, the page 51.
Oh,
This is their own admitted petition. They have
No, I'm in custody in connection with
kindly see
Presidency Collectional Home. No doubt about
page,
that.
page 26. My lord, he has made a chart. There your lordship will find page 26.
And my lord, there are other cases against me where, my lord, I'm not in custody. I mean, sorry, my lord, I'm not on bail. Which is why, my lord, even if I furnish bail
It's
bond
in
one case-
Delhi. It's not here. It
So
is in
therefore,
Delhi.
therefore, no chance of fleeing away, my lord. So the first criterion.
Allegation is you running the drug cartel, staying in presidency jail.
My lord,
Fleeing is not, they are not.
I'm obliged.
You
If that
don't
is
have
so,
to flee.
if that is so, what they have argued before your lordship, similar arguments were made before the Honorable Single Judge at the time of bail. There is no recovery, nothing. The bail was granted. The order was never challenged. Now, in a circuitous way, my lord, which could not have been achieved in the pending criminal proceedings, my lord, where I am on bail. Now, they filed preventive detention. They invoke preventive
And prior
detention.
to the bail order. Prior
My lord,
to the bail order.
16th May order is prior.
My lord, whatever might be their ground, my lord, allow me to argue before the Honorable Single Judge where my bail is, sorry, my lord, my writ petition is pending.
Your preventive detention order was placed before the sessions judge.
No. Preventive detention order. My lord, kindly
Yes,
see.
and which is why, my lord, I obtained the copy.
No, my lord, kindly see it.
I obtained the copy, my lord, which is why.
Received 2 letters, similar
letters from-
prayers, along with copy of order of joint secretary and endorsement of.
No, this is only leading to my lord, the transfer of the my lord, the accused from my lord, Kolkata to my lord, the Rajasthan.
For
Not
this
about
order
the-
only.
Joint secretary's letter is referred to there, Mr. Majumdar.
It opens up with that, my lord.
Joint secretary's letter.
No, it was received from, my lord, kindly see, received 2 letter having similar prayer along with a copy of Sri Anupam Prakash, Joint Secretary and endorsement by Sri Kishore Bandyopadhyay, Deputy Secretary.
So along with a copy of the order of Anupam Prakash. So what is the order of Anupam?
Well, that's the order impugned, my lord. Impugned, my lord. Page 50.
From the, my lord, kindly see, it's from the Superintendent of Presidency Correctional Home.
No. Anupam Prakash letter, copy of the order of Anupam Prakash, Joint Secretary, Government of India.
Yes. Yes.
That is the preventive detention order, Mr.
No.
That is the order. Anupam.
But this has been given by the Superintendent of Correctional Home. We have not given. We have not given. This was given the Superintendent of Correctional Home. Kindly see the language, my lord. It was from the Superintendent of Presidency.
Because you have provided it to the Superintendent of Correctional Home.
I have to provide it.
So therefore, it's available.
I have to.
If now
regarding the
takes up
I'm
in
sorry,
public,
I'm
it is
sorry.
his due. It is his fault. Yeah, it is his fault. There is.
You should not have started.
No, that's their, I mean, argument. I mean, the ground they have taken. If that is so, then I have a better case, my lord.
Although,
Dismiss the appeal is not maintainable.
My lord, we don't want to, my lord, trace it
If
before
that
your
is so, my lord,
lordship.
I tell your lordship why, my lord. Your lordships are aware of, my lord, Fauji test, that if it is a criminal matter, police connection, so then therefore there cannot be LPA appeal, my lord.
No.
And my lord, just to satisfy, my lord, justice,
No, Mr.
Mitro's
Bhattacharya,
query, my lord, regarding, my lord, the dark web. I'm sorry.
You are in custody.
My lord.
Today you are being shifted from presidency to another jail in Jaipur.
My lord.
There is a semblance of preventive detention issues involved in the matter.
My lord.
What prejudice you will suffer?
Might
prejudice you will suffer, because today, if they do not take coercive actions, means what? What are the coercive actions? They would be shifting you from presidency to another jail, where they would continue with the preventive detention proceedings, which you have a right to challenge. So today, what is your justification that don't touch me now, you keep me in presidency, vis-a-vis his allegation, that you are running something or doing something from presidency jail itself. Good, bad, indifferent. We are not believing that. So what prejudice you will suffer, Mr. Bhattacharya? This is in the national interest, it is being done.
The preventive detention law is for national interest, no doubt. But your lordships will also, I mean, will be with me in saying, my lord, that this is an exception, because preventive detention is on, my lord, some rational basis. Now, my lord, the general rule is that, my lord, the punitive law, what we have in India, that Narcotic Drugs and Psychotropic Substances Act. My lord, there are proceedings where on similar allegation, my lord, I am on bail and I'm facing trial. There are 6-7 cases. Now, my lord, these dark web, etc., these are sophistries, because these were argued before the court. Despite that, I was granted bail. Now, once they fail to keep me in custody in terms of the law of the land, in terms of Article 21, now they invoke the preventive detention. And so far my shifting is concerned, kindly appreciate, till date what custody I suffered by virtue of a legal proceeding, initiated and continued in terms of Article 21, read with 14. Now, preventive detention, the moment, I am taken to Jaipur, so the order is given effect to the order which is, under challenge. Now, there is no embargo under any law, anywhere, with deepest respect, that a preventive detention order cannot be challenged in writ petition unless it is executed. So, my lord, I have challenged at the very threshold of it, and your lordships have seen the order, my lord. Is there any semblance of reason? My lord, that's seen page 50, my lord. It says that, look, I am satisfied, I am asked to be satisfied, I am satisfied.
Subjective satisfaction.
The term used is subjective satisfaction in the act.
My lord, what I have learned from your lordships, my lord, please, my lord, whatever I have learned, my lord, there may be, I mean, lapses on my part in learning. But the best way of demonstration of satisfaction is recording thereof. But how and in what manner, my lord, the subjective satisfaction was arrived at has to be mentioned, has to be whispered.
Under the old act, 1940 Arbitration Act, you did not have to give a single reason as to why and what award you are passing, and that was considered to be the best award. I think the claimant is entitled to rupees 10. Finished. And you couldn't find reasons and ways to challenge
I'm
it.
obliged for this, my lord. Let me answer, my lord. I'm deeply obliged, my lord. This is a privilege to address your lordships. My lord, that is right to property, and here is right to life under 21. So, my lord, the measuring scale, my lord, kindly appreciate this.
With some reservations, with some parameters.
But there has to be something in the order, my lord. My lord, I tell your lordship, my lord, in the code of criminal procedure, please, sir. My lord, in code of criminal procedure, well, what I pray before your lordship, my lord, let him argue before the honorable single judge, because my writ is pending. Today, if the interim order is, my lord, it's touched upon, my lord, or is modified, my lord, the writ will be infructuous. Or if my lords want to hear me, my lord, kindly grant me time. I will file a short affidavit. Your lordship will hear out the main matter. It's not that, my lord, I want to flee away from the court. I will argue before your lordship. Only grant me an opportunity to file a short affidavit in that case. I'll come back to your lordship. Your lordship dispose of the main matter.
Yes, what do you say, Mr. Trivedi?
My lord, I am for respondent number 2, my lord. Only 2 points, my lord. I have nothing more to say, my lord, because it was initiated by us. My lord, the process is that whatever from I am also perturbed by seeing this order, where my order has been reflected. Actually, my lord, this was to be executed and we need certain permissions from the court or from the department of that presidency correctional home for this particular deportation. Now, my lord, it was mentioned before the learned judge for getting certain permissions. Now, that should have been kept confidential. Now, that was reflected in the order, my lord, because it is dealing with all these secret documents, my lord. So, but, my lord, then also I still repeat and reiterate that the impugned, that annexure, that how did he procure that? That is still a mystery for me. That is page 50.
I made a statement. It was communicated to the jail, to the court. I got it.
How, my lord,
And that will file an affidavit to that effect, my lord, in my opposition.
My lord, I may be wrong, my lord, what I'm trying to impress, my lord, because I am the authority, I have nothing to, I have issued a particular preventive order. Now, my lord, whatever they are coming, the defense which they are taking, it was circulated, it came to their knowledge by the order dated 9/6/2025. Even then there could have been made an averment or a statement on oath that from this order I have come to know. How did he procure page 50? This, I'm still in the dark. So, my lord, why I am trying to point out very humbly before your lordship that the resources of this gentleman in presidency jail, the resources. Now, my lord, this is a confidential document. I have to share it with the correctional home superintendent for other nitty-gritties to be worked out. He has to take permission from the concerned court. Now, that concerned court, without understanding the nuances of the matter, makes it public in the order. Now, my lord, even justified. My learned friend's client may have a case that he learnt this from this particular order. So he should have annexed this particular order and come on affidavit. That this is how could he procure that document? I'm just, lordship, on his resources.
And with regard to please,
the order is placed before the court of law. It's available with everybody, my lord.
Certified copy, my lord, I don't think the certified copy.
No, certified copy will never be, sir. It's certified copy will never
Two letters. Presidency, to the presidency, an intra document.
Yes.
Well, only one thing, your lordships have seen the order, my lord, of the learned trial court. See the top of that order. Record is put up today. Once my lord, any application is filed by way of a put up, my lord, the other side is informed with a copy thereof.
That you have not stated in your petition, Mr. Bhattacharjee.
But that point was not taken, my lord. I will file an opposition. I will file it, my lord.
The document you are producing, your only averment is at page.
Paragraph 10. Paragraph 10, Lordship, I say.
Your averment is in paragraph 10. Petitioner pursuant to filing of bail application, sought multiple adjournment, application pending. Petitioner on such and such was shocked to find an order. This is the only line you have used. Nothing else.
My lord, I will better it, my lord, by file because I have emailed the way it was communicated to me. I'll file by way of opposition, my lord.
Interim order. Let the order take effect. Your preventive order will be under challenge before the writ court.
But then, my lord, my writ will be infructuous, my lord.
Yes, what can be done?
But issue is that, my lord, today your lordship,
we do not find that there was anything in your favor.
but your lordships are deciding, my lord, the interim order, whether the interim order should have been passed or not. No, but here kindly appreciate, my lord, this is an interim order. Had this not been passed, my lord, the writ would have been infructuous. Because I cannot, then your lordships are dismissing, in fact, my lord, effectively the writ. It's only habeas corpus which I can file. Now, my lord, here, the only on the ground that I have annexed a document, the source whereof has not been disclosed, when the authenticity of the document is not been questioned, my lord, kindly appreciate this. Had it been a case that, look, I relied on a document, my lord, which is not authentic, well, it can...
All the more reason that you got an authentic document which you're not supposed to.
But there is no bar in getting the document, my lord, kindly appreciate.
Prior to execution.
Prior to execution.
But there is no bar in obtaining the document prior to execution, my lord. But it's like I can have an FIR prior to my arrest.
Tell us where you have said that. How did you get it? You came to learn. No other averment is there.
Well, now they are taking this question, my lord. I'll just file an affidavit. I'll come back to your lordship. Give it short date, man. I'll come back to your lordship. I'll just give all detailed communications.
What? Tell us affidavit. What affidavit?
But that the communication from the jail to me by email, the order was served. Everything will give, my lord.
Jail authorities are involved.
So,
at the end of the day, my lord, the order is genuine.
So it's
that is what I.
Well, it's like, my lord, kindly appreciate. My lords were there, my lord, in the criminal jurisdiction, my lord, as a Chakraborty, subject to correction, my lord. I can annex a document, my lord, FIR, though without obtaining the certified copy. The issue is, my lord, if the FIR is genuine, my lord, then I cannot be called into question, my lord. If FIR is forced or something else, my lord, then definitely it can be. But it's at the end of the day, my lord, my detention, my lord, my Article 21, my lord, I am on bail. They have never challenged that order, but the learned special court has refused their prayer of remand.
Court will consider your main prayer. Preventive detention.
But there cannot be any bail, my lord. In preventive detention, I cannot have any bail, my lord.
No, not bail. You are challenging a 226 application, challenging the veracity of the order of 16th May.
No, my lord, if today, my lord, it is dismissed, my lord, then I cannot challenge that on the ground that the lack of jurisdiction or patent illegality in the order because I have taken those points, my lord.
Jurisdiction.
Kindly appreciate, my lord. Here, my lord, it will be infructuous, my lord, my rate. So what I beseech your lordship, my lord, if your lordships want to hear, my lord, kindly have it next week. I'll file the opposition, my lord. Your lordship will take it up on next week, my lord. Any day, barring Monday, any day that's convenient to your lordship, my lord, I'll do that. I'll file my opposition, my lord, by Friday. Your lordship can have it, my lord, decide the rate. Your lordship may dismiss it if your lordships are not with me on, my lord, the source of that order. But I'm telling your lordship, my lord, in a criminal matter, source of an order, if the order is not, otherwise, my lord, a forged one, or I mean, the genuinity is not questionable, my lord, can be relied on, my lord, with deepest respect. Only, my lord, Monday I have some personal difficulty, my lord. I have personal difficulty, not for any other reason. I'll not be in Kolkata. Give me any date, my lord. Give me 15 minutes, my lord. I'll satisfy you.
Not a criminal matter, my lord. The law of the criminal matter will not apply here. My lord, this is a preventive detention order, my lord. Your lordship has gone through the order. My lord, and my lord, the continuous view of the Supreme Court.
Vacation of the interim order, the writ petition goes. Nothing remains in the writ petition. So let him come. We are fixing it on Monday. let an affidavit be filed. We will record he has no objection if the main writ petition is taken up for.
Please, my lord, your lordship will dispose of writ petition. Please, my lord, I'm deeply obliged.
Confidential record.
My lord, it's a tampering with the confidential record. Your lordship.
Bro, how can that be
How
tampering?
can we are giving it back to you.
No, the document,
Yes,
which was not supposed to get, my lord, there is no averment in the writ application.
Mr. Mojumdar,
yes.
Today, if we vacate the interim order, writ petition, nothing will remain. So, when he has consented that the main writ petition may be heard out, we are using an opposition to that effect to hear out the writ petition. We are fixing up a day, finish it off. Your writ petition will go, your appeal will go.
My lord, kindly see their prayer. It will not be infractuous. Kindly see it, my lord, what they have challenged.
Tomorrow morning, it's already 4:30. Whatever explanation you have, you tell it to us tomorrow. If you want to use any sort of other documents, come back with the documents. We'll pass our order on that. We will take up the final hearing, then so declare.
Actually, I was in a mind to use one short affidavit, my lord.
That's what, Jaji, when there is a contesting matter, you assist.
They have never contested before the honorable single judge. That's the agony I have. Simply they ask for time that we will file report. Now suddenly, my lord, they wake up from the slumber and they say, no, hurriedly, it has to be disposed of.
Filing of report.
Because, my lord, ultimately, that's ground of challenge. Assuming, my lord, the order is given effect to, my lord, then the ground of challenge will efface out, my lord, if this writ fails. So either I win before your lordship or, my lord, I lose.
So tomorrow you come with your record.
But I was in a mind to use one short affidavit, my lord. Instead of tomorrow, my lord,
affidavit for what reason you?
I'll just annex the documents, my lord.
Which document?
But the source of knowledge and source of obtainment of the copy, because that's the main question now they have raised, my lord. They are not on anything else, my lord. They are on the how did you obtain the copy when we did not serve you officially. That's their ground, my lord. My lord, I am requesting for any date barring Monday, my lord. Tuesday, Wednesday, any day that's convenient to your lordships.
Affidavits will set the matter on the.
By Friday, I will file the affidavit, my lord. By this Friday, I will file the affidavit. I am requesting for 2 days only. Monday, I have some difficulty, which is why for hearing, I am requesting for Tuesday, Wednesday, any day that's convenient to your lordship.
Mr.
But opposition will file by Monday, by Friday, this Friday.
Mr. Mojumdar,